Okay. Good morning, everyone. I'm just going to give it a few more seconds just to let more people get on. But thank you for joining us this morning. Okay, so I think we're going to get started. So once again, good morning, everyone. Welcome to our webinar today. Thank you for joining us. My name is Tim Chance. I am the Tangled Title Attorney at Maryland Volunteer Lawyers Service. Today's webinar is called Disentangling Deeds, the Basics of Property Transfers and Estate Administration. So I just want to go over a few quick housekeeping items before we start and hear from today's three wonderful presenters. So firstly, the audience is going to be muted during the presentation, but if you have any questions, you can enter them in either the chat or question portions of your webinar toolbox. I will monitor those and relay those questions to the presenters at the end of their presentations. There's a few handouts that are available, and that should be in the handout section of the toolbox. There are further handouts that I'm going to be emailing to the individual attendees. But if you have any issues, I guess, accessing the handouts that are already uploaded, just let me know and I can get those to you directly as well. So lastly, this webinar will be recorded and available on MVLS's website. So you will have that as a resource if you miss anything or if you want to go back to review the presentations today. So today's webinar deals with the issue of tangled titles that many people unfortunately find themselves in. We will hear from three speakers today. First, providing an overview of estate administration, we have Alice Young. Secondly, we have Richard Adams, who's going to dive into some of the more practical details of estate administration and some of the issues that many of our clients and volunteers find themselves facing in estate administration. And third, we have Cristin Lambros, who's going to go over property transfers in the context of estate administration. Okay. Well, our first presenter, Alice, has been doing estate administration for several years now and has been active with MVLS as a volunteer, as a mentor, and as a presenter. So we are very grateful to have her here today. And without any further ado, I'm going to pass controls over to her.
Thank you, Tim. Just confirming, super. So I'm going to show my screen. Tim, you can hear me, right?
Yes.
Super. And you see my presentation?
Yes.
Super. All right. So welcome, volunteers, and I'm so happy to be a presenter for MVLS today. Today in particular is a special day because today is Giving Tuesday. Cinco de Mayo is a day that has been designated in this time of isolation for giving back. And if you are inclined to give financially, MVLS is a great organization to donate to, and there are many other laudable organizations to give your dollars to today in recognition of Giving Tuesday. And in addition to giving monetarily, you as being a participant in this webinar, I believe have volunteered to take an estate administration case. So the purpose of my presentation today is to ready you for serving as a volunteer attorney for low-income Marylanders who need assistance with this process. And as Tim is the tangled title attorney for MVLS, we can be assured that there are plenty of tangled titles here in Maryland in need of disentanglement. What we're going to focus on today for the first half of the talk is working through estate administration, general estate administration tasks. And then my colleagues are going to cover some of the more complex issues that come up in estate administration, like issues with heirs and creditors and the medical assistance program through the Department of Health, and some various ways of passing real property title. And most importantly, Ms. Lambros at the end will be talking about how to avoid probate altogether by passing real estate outside of probate. But before we get all to that fun, we're going to walk through estate administration generally. I'm an attorney with Nusinov Smith in Baltimore County. My primary areas of practice are Baltimore County, Baltimore City, and Howard County, Harford County, the surrounding counties, but primarily Baltimore County and Baltimore City. And so I'll be giving some examples today of estate administration in those jurisdictions. And in addition to the area of estate administration, our firm also practices in guardianship administration and fiduciary litigation. So some of the examples I'm going to walk through today include touching on those types of topics, fiduciary law topics, and how they lead into estate administration and how they inform estate administration. So the overview of what we'll discuss today in the first part of the presentation is what falls into and what does not fall into probate, some types of ownership and how types of ownership help avoid probate, inadvertently or intentionally, what constitutes a small estate and a regular estate, how to open an estate before a register of wills resources available to you as a volunteer attorney, and some basics of distributing assets out of an estate. We're going to walk through an example of an estate. For attorneys who do pro bono work with MVLS, generally the estates that come through MVLS are don't involve a lot of work before the courts. So generally a case that you get from MVLS will not involve appearing before an orphans court. Ricky's going to get into some examples of times when you might have to partner with another attorney to accomplish certain estate administration tasks. But generally speaking, these are great cases that don't involve litigation or contested issues. And MVLS is very good about providing cases to volunteers that are suitable for the volunteers to take. We're going to start with estate administration. What is probate? What is an estate? And then we're going to get into opening an estate, steps of estate administration, claims against an estate in a general sense, and general distribution. And then we'll look through a sample accounting and talk about passing property out of an estate. We'll leave some time for questions at the end of my section of the presentation, as well as the other speakers. So at the end of my 2 hours, we will be taking questions on the topics that I tackle. Before I get into the nuts and bolts of probate and opening estates before the register of wills, I just want to touch briefly on income taxes. A more in-depth talk about income taxes is beyond the scope of this conversation, but I do just want to make it clear that people who have passed away often need to file a final personal income tax return, a 1040 or a 502. And additionally, estates might need to file fiduciary income tax returns, a 1041 or a 504 here in Maryland. So income taxes are part of estate administration, whether it's a final personal income tax return for a decedent or a fiduciary income tax return for an estate. And if you are not familiar with filing income tax returns, or you're not familiar with the level of income that makes it necessary to file an income tax return for an individual or a fiduciary, you should make a friend of a CPA who is familiar with that and partner with a CPA to get information from the IRS with respect to that decedent under that decedent Social Security number, or if this is an estate that's been open for a while, also partnering with a CPA to get information from the IRS or the comptroller with respect to the fiduciary estate or the tax identification number that was issued on the decedent's death. So income taxes are beyond the scope of this talk, but they are a part of estate administration, and you should be aware that you may need to partner with this accountant to get information about what you'll need, what you may need to file while you're advising the personal representative of an estate. Estate and inheritance taxes are also part of the conversation of estate administration. We're going to touch a little bit on inheritance tax later, but I want to briefly talk about an estate tax. And lots of times in popular media, you'll hear the phrase death taxes and politicians whipping you into a froth about the need to avoid death taxes. But I want to assure you that the estate tax scheme in place now exempts the vast majority of people from the need to worry about estate tax. The federal exemption amount right now is 11.58 million, which means that an individual on that individual's death can pass $11.5 million without worrying about paying a federal estate tax. Here in the state of Maryland, our estate tax exemption is $5 million, which means an individual can die with up to $5 million without worrying about the estate having to pay an estate tax. Married couples, both at a federal level and at the state level, get to transport by means of what's called portability their predeceased spouse's unused exemption amount. So married couples, we can generally say, can pass more than $22 million without worrying about federal estate tax, and can pass $10 million without worrying about Maryland estate tax. So the conversation, the public policy conversation about death taxes and the need to do planning to avoid death taxes, those issues at this point are issues that are concerns of very wealthy people and not the average Joe. However, inheritance tax can touch every family, and inheritance tax can be more onerous than an estate tax. Inheritance tax is a Maryland tax that is due on the receipt of a gift from a decedent, and it's 10%. So if you receive a gift from a decedent, somebody dies and you receive something as a result of their death, if you are not closely related to them, you will owe the Register of Wills 10% of that gift. This is an important source of funding for the Register of Wills, so you can imagine the Register of Wills takes great care to seek it out and collect it. It's 10%, and that when you talk about receiving, for example, an IRA of $100,000 and turning around, you have to pay $10,000 to the state of Maryland if you're not a close relative. That can be a headache, and one way of avoiding that headache is to do good estate planning. So MVLS can assign you estate planning volunteer cases as well. And if you do any estate planning in your general practice, you must be aware of and be able to counsel your clients on the impact of inheritance tax. There are ways to mitigate it, there are ways to avoid it, but proper planning is important. So we'll talk a little bit here about what is probate, what goes in and what doesn't go into probate. And a lot of probate is filling out forms. So the nice thing about taking a pro bono case through MVLS for estate administration is you don't end up in front of the court a lot, and you have to become familiar with the forms. The good news is that you are never alone with the when you're doing MVLS estate administration cases. Not only may you be connected with a mentor for estate administration, another volunteer attorney, but you also have the vast resources of the Register of Wills. And Tim, just to make sure you can see the Register of Wills website on my screen.
Yes, that's up.
Super. So the Register of Wills website has publications and sample guides. In addition to that, they are staffed by people oftentimes who've spent their career assisting laypersons with the administration of loved ones' estates. And the first step for any estate administration is to give a phone call to the Register of Wills and talk to somebody in new probate proceedings, just to make sure you're getting all your the papers that they will want to see. You're getting them all situated. One of the publications that I'm going to refer to throughout this talk is the sample account here. There's a PDF sample account, and you will, as a volunteer attorney, want to take a look at this. I'm not going to go through this exhaustively. It's a long publication, but it is here as a resource, and it's something that you will want to remember when you take a volunteer case, that you can always look at the sample account to see some topics that perhaps you had forgotten from this talk, or it might trigger you to ask a question of the Register of Wills that you might not have otherwise thought to ask. So it is a resource, and you want to take advantage of the resources that the Register does provide, in addition, of course, to talking to the Register, the Deputy Register in the new probate proceedings, to get many questions answered. So probate versus non-probate, and just in case you are a etymologist and interested in the origin of the terms we use, probate is from the Latin to prove, and what probate means is proving before a government entity what is passing upon the death of a decedent. So when you put something through probate, you're proving something to the government, and it's just a way of making sure that what happens after somebody dies is what in fact is supposed to happen after somebody dies. Non-probate is property that passes without needing to be proven to the government. Non-probate assets pass outside of probate directly to new owners on the death of a decedent. So your probate estate, things that will pass and be reported to the Register of Wills or the Orphans Court, include property titled solely in the name of the decedent, and that includes real property, whether it's titled solely in the name of the decedent or whether the decedent owns that property as a tenant in common with somebody else. And an example of that is when somebody's parent dies and they don't otherwise designate a real property to pass a different way in their will, that parents' children may inherit that property as tenants in common. And so you may have the name of 1 or 2 or 5 heirs or children of the decedent on a deed, and if that deed is by tenancy in common, then when one of those people dies, that portion of the property has to pass through that decedent's estate. Bank accounts can be titled solely in a decedent's name, or, as you know, they can be titled jointly with another owner, or bank accounts can be titled as pay on death, designated specifically to be paid to a recipient on the death of the primary owner. So one part of estate administration is looking at bank accounts to see how they are titled. Is there another person's name on it? Are there the letters POD next to it? Going to the bank with your client, or sending your client to the bank with letters of administration and a death certificate, and trying to extract information from a bank about how the account is titled. Cars and other tangible personal property can be titled solely in the name of the decedent, With a car, it's titled property. There's a title from the Maryland Motor Vehicle Administration, and so you need to look at the title to see how it's titled. It could be that somebody comes to you and says, oh, you know, I need to open an estate to pass grandma's car. But when you look at the title, perhaps there is a joint owner on grandma's car. Or Maryland now has the ability to have a pay on death or transfer on death designee on a car title. So now you can transfer cars outside of probate. So you really do have to indulge in your curiosity as an estate administration attorney and investigate what the actual titles of property are. You have to look at car titles, you have to look at bank statements, and in addition to that, to deepen your interest in real estate, as we all have curiosity about property law, go ahead and sign up for the free access to the Maryland land records. It's a free resource. It's PDF images of deeds in all the jurisdictions in Maryland, and you sign up for username and password, and then when you become involved in either estate planning or estate administration, you can see the deeds that are scanned in to the Maryland land records, and you can yourself read how those real properties are titled. And this there's nothing that speaks to being a lawyer as much as actually reading the document that your client's referring to, and they're relying on you and your expertise to tell them what this means. I recently mentored an attorney who's been doing estate planning for a couple of years, and learned that that attorney didn't have access to the Maryland land records, and it's hard to do estate planning, in my opinion, without examining the deeds of the properties owned by the people you're representing. So it's sort of a step one of getting to know the estate administration situation or an estate planning situation. Non-probate estate, assets that are not passing subject to examination by the government, include property held taxable to the decedent at death, but considered a separate entity, so, or passing by contract or beneficiary designation. One example of that is a revocable living trust. And if you do any estate planning or have walked through any estate administration of family members, you may have become exposed to revocable living trusts, which are very common ways of avoiding probate. It's essentially creating a bucket. The person doing their estate planning puts certain assets in the bucket by retitling. For example, you can retitle a brokerage account to be owned by your Rev Trust, or you can retitle your house to be owned by your Rev Trust. They're still your property for the purposes of income tax. So any dividends or interest you earn on that brokerage account, you still file, you still report that on your personal income tax return. But when you die, the property passes under the terms of the trust and is not reported through probate. It's still your asset at your death, but it's not reported through probate. Another example of non-probate property is real estate that transfers on your death to a surviving tenant or remainderman by operation of law, for example, to a joint tenant or a tenant by the entireties. Reach way back into your memory of your first year property law class, and you'll remember tenancy by the entireties is a tenancy reserved for married people, and it gives certain protections. So tenants by the entireties, if you see that in a deed, it will suggest that the people at the time of the deed were married, and it will suggest that the surviving of those two people is the sole owner on the death of the first spouse to die. Now that changes a little bit when somebody divorces, so you have to, again, give into your curiosity and dig deep and get interested about the life of the decedent so that you understand what those terms mean in the deed after they've died. Bank accounts as well can transfer to joint owners or by operation of law at death. So if you have a joint owner on a bank account or savings account, that surviving joint owner will own the account upon the decedent's death without any other steps needed to take. You can take a death certificate to the bank and have that account title updated, but even if you don't do that, that surviving joint owner is the owner. Cars and other tangible personal property, as we discussed, cars can also transfer outside of probate if there's a joint owner or a transfer on death designation. And tangible personal property can be jointly owned, and Ricky may get into the some of the disputes that arise with tangible personal property, and they can be some of the most emotional and costly disputes of estate administration, because it's hard to say who owned what. And if somebody has their eye on grandma's silver and grandma didn't otherwise designate it, it can be a little bit sticky. So tangible personal property, although it may not be of significant value monetarily, it can be of significant value emotionally, and it's something that you want to be aware of as you're doing estate administration. So the red circle here represents the total estate of a decedent, including trusts, probate property, and non-probate property. And this little piece of the pie is the probate estate that's subject to administration before the Register of Wills. You can have a very wealthy person with millions and millions of dollars in trusts and non-probate assets and have a small probate estate. And it's just something to be aware of, because small estate does not mean that somebody's poor or that they don't have enough money to pay their creditors. It just means that they did great estate planning and have minimized the amount of money that has to be proven before the Register of Wills. A small estate is a technical term. It means the limit, it means the amount of money that can pass under certain rules of the code. And here, this is a chart of small estate limits back in 1965, 1982, 2012 to present. For the last 8 years, a small estate has been $50,000 or less, and $100,000 if the spouse is the sole legatee or heir. And what that means is a small estate is subject to fewer reporting requirements before the Register of Wills. It doesn't save a whole lot of money, but it does save some time in the reporting requirements. Oh, just a word on bonds. A bond, it says here in the box, a bond may be required if assets exceed debts by $10,000 or more. A bond is an insurance policy that the Register of Wills may require that the personal representative purchase, that insures against the personal representative stealing all the money. And for better or worse, this happens all the time. So it's a good thing that bonds are required. And bonds cost money to purchase. So when you're working with the pro bono client through MVLS, one of the hurdles to estate administration is coming up with the $100 to pay for the bond. And it is a real struggle, and it's something to be aware of. MVLS has put a lot of time and effort into lowering the hurdles to allow people to access the Register of Wills, administer estates, and pass real estate to new owners. And they've gotten cooperation with the Register of Wills for things like reduced probate fees and other costs, but there's still this bond issue, and a personal representative's bond. There are two types of bonds, a personal representative's bond and a nominal bond. And a personal representative's bond can be quite expensive. So it is something that will come up in the course of estate administration, and MVLS does have a lot of resources to assist with this. So if you find that your pro bono client is struggling with certain costs of estate administration, reach out to MVLS to see what resources are available to mitigate those costs. We're going to talk, I'm going to use the words testacy and intestacy in the next several slides, and I want to explain testate or testacy is when somebody dies with a will. A will allows a testator or a testatrix to leave instructions about what should happen after death. In other words, you get to say what happens to your estate when you die. Intestacy, or dying intestate, is when you have not written your own will. What that means is that the state of Maryland has an estate plan for you, lucky you, and we trust our legislatures to do all sorts of things for us. So the legislature has come up with an estate plan for you, and if you don't do a will, that's the plan that will be in place at your death. This is a resource in the sample accounting. This is your will if you have not written your own will. So this is the state of Maryland's estate plan for you. I'm not going to walk through all of it, but I do want to highlight a couple of things. One, if you're married, your spouse will receive a share of your estate, but not your entire estate. So for all of you lawyers in the crowd who haven't done your wills and you're married and you think that, oh, I'm married, so I've solved my estate planning problem, that is not the case. You still want to do your own will to make sure that your children don't share in your estate with your spouse unless that's what you want them to do, or that your parents don't share in your estate with your spouse unless that's what you want them to do. Because if you're married and have no children but have living parents, your estate is divided between your spouse and your children. It's something that you need to be aware of for yourself and your clients. Wills are important, and it's important to get your own estate planning done. And here, it's important for when you're walking through pro bono estate administration that you're able to access this resource and explain to people, your clients and the other heirs of the estate, how the estate is going to pass if somebody has failed to make a will. So you've been assigned a case through MVLS, and now you have to open an estate. This slide gives you a diagram of who has the standing to open an estate, and it can get a little bit complicated. You'll see the word testacy and the word intestacy. So if you die with a will, you get to nominate who serves as your executor. And that means the person nominated in your will has the highest standing to open the estate. If that person is deceased or refuses to serve, then it's the spouse of the testate decedent. If there is no spouse or that person refuses to serve, then it's the residuary legatees of the testate decedent. On the other hand, if you don't have a will, if you're passing your estate through intestacy, then your spouse and children have the standing to open your estate. What that means is your spouse and children would have to agree which of them would serve. And that can be complicated. That's why it's always important to do a will. If you have an MVLS client who, just as an example, it's a granddaughter who's living in her grandmother's house, and she goes through MVLS and qualifies for pro bono representation. She comes to you and says, I need to open this estate because I need the homestead tax credit and I need to get, grants to improve the house for energy efficiency. Let's open the estate. She does not have the highest priority to serve if there is a living spouse of grandma or if there are children. That could be her parent or her aunts and uncles. And she would need their consent in order to become the executor of the estate. So before you fill out all those papers to open the estate, you need to figure out who has the standing to complete that paperwork and how to overcome any standing issues. You also need to identify interested persons. Interested persons, this is a term of art in Estates and Trust 1-101, and interested persons have to be listed on the list of interested persons. They include a will-nominated executor, whether or not that person is going to serve, they're still interested person. A legatee, a legatee is somebody who is listed in a will to receive a gift. The person serving as the executor, the heirs of an intestate decedent, so the heirs of somebody who didn't make their own will, and the heirs of a testate decedent, but only until they have been served notice of the opening of the estate or notice of a petition for judicial probate. So the heirs of a testate decedent are the people who would take of that decedent's estate if that decedent hadn't made a will. but a testate decedent did make a will. So the heirs of a testate decedent are the people who would take if there wasn't a will, and because there is a will, their interested person status is limited just until they've been served notice of the judicial probate petition or notice of the opening of the estate. And the purpose is, if somebody is promulgating a false will, this gives the heirs proper notice that they can fight that will by means of a caveat. So these are the people who must be listed on the list of interested persons that you file with your petition for probate or within 30 days. This slide of the family tree is a graphic available on the Register of Wills website, which I've included here for the purpose of illustrating everybody has heirs at law. Your heirs at law are the people, what sometimes referred to next of kin, people who would take of your estate if you died intestate. And it can be your children, if you have children, your spouse, if you're married, your parents, if you have neither children or a spouse, or your siblings, if your parents are both deceased. Oftentimes people say, well, this client has no heirs, or, this person has no family. And in fact, everybody has heirs. This family tree goes up to the great-grandparents and devolves after that through the third cousins. And if you have somebody, if you're opening an estate for somebody who doesn't have any close family, your task, either as the attorney for the estate or as the personal representative, if you're sitting in those shoes, is to gather information about who those people are so you can properly notify them. Estate administration can be overturned if you've not met the burden of proper notice. So this is a sample piece of paper that you can fill out on the Register of Wills website. That's the list of interested persons. It's small print, and of course you're all looking at your computers. I'm thinking this is on a screen somewhere, but you are in fact right in front of this, so you can see it. The list of interested persons, you must list the name of the person who's interested in the estate, and you have to note if they're under 18 years old because there are different rules that apply for minors. Their last known address, including the zip code. In the fourth column, you have to specify what their relationship is to the estate, and it gives examples here: heir, legatee, personal representative. And there are some times when an interested person is all three of those things. For example, if you have a surviving spouse that is the will-nominated executor and the heir or the legatee under the will, then you have one person who is not only an heir, but also a legatee and seeking appointment as the personal representative. You have sometimes when a person is only one of these things. For example, if a friend is receiving a gift under a will, that friend is not an heir at law. It's not a blood relative who would take of the estate if there was no will. And that friend is not seeking appointment as the personal representative. That friend is just a legatee. So this list of interested persons could be one page if it's a small, for example, if it's an intestacy with a surviving spouse and one child, that might just be two people. However, if it is a testate decedent with many gifts in the will and also heirs at law who are not in the will, this could be many pages long. So the list of interested persons, you have to, again, indulge your curiosity, find out what the relationships are between the decedent and each of the people, and make sure you're listing all the people who have an interest in the estate, whether it's by means of being listed in a will or by means of blood relationship that entitles them to the term heir at law, if they have to be notified of the filing of a will, or if they are in fact taking under the intestate estate. And then of course the final column says relationship to the decedent, and it could be that their person has no relationship to the decedent. If it's a independent personal representative, for example, it could be a friend or a niece or a cousin or a sibling or a spouse, but you have to list the relationship to the decedent. And this goes back to the Register of Wills source of funding is inheritance tax. They want to know who these people are so they know if they can collect inheritance tax from the estate. When you're opening an estate via administrative probate, you'll need all the things the Register of Wills requires to open the estate. Administrative probate means that the Register of Wills has all the information it needs and it will issue letters of administration without the need for a court hearing. The flip side is judicial probate, and judicial, as you might gather, involves a court. So administrative probate is proceeding with probate without the need for the court to be involved, and judicial probate requires court intervention for one reason or another. To proceed with administrative probate, if there's a will, you need the original will. You can't proceed with administrative probate with a photocopy of a will unless you have consents from all interested persons. You need the person with the highest priority applying for appointment. So if you have a grandchild as your client and there are surviving children of the decedent, you either need the children to apply for appointment, or you can represent the grandchild in applying for appointment, but we have to have consents of all the people with higher priorities to serve. The petition for probate, the list of interested persons, the asset lists. On a small estate, it's called a Schedule B. On a regular estate, it's called a Schedule A. An original death certificate, notice of appointment, notice to creditors, and costs and fees. So the Register of Wills, there are certain costs and fees they're going to collect up front. So when you have a pro bono client and you're helping them seek appointment through estate administration, they do have to come up with some money in advance. And if your client's having trouble with that, please reach out to the NVLS because they have methods of mitigating some of those costs. Here's an example of a petition for probate. You'll see at the top, you get to choose which jurisdiction in the Orphans Court or the Register of Wills for whatever county. There's no estate number before you open the estate, so if this is an initial probate petition, you won't have the estate number. There are places across the top for regular estate, small estate, will of no estate, and limited orders. So this single petition can be used for multiple purposes, either for a regular estate, a small estate, a will of no estate, or limited orders. This is one place where you might want to pause and call the Register of Wills in the new probate proceedings and ask the question, I have these facts, I'm doing this, and please let me know, am I filing a small estate, or would you suggest a different tack? Because you want to get this right if you can before you send it in. You name the petitioner, the address of the petitioner, and then you recite certain facts. You are making a affirmation here. On the second page where you sign, it's I affirm under the penalties of perjury the contents of this document are true to the best of my knowledge, information, and belief. So you want your client to give you accurate information so that you are not misrepresenting anything to the court. At the top of the second page of the petition for probate, there's a place for you to indicate if the petitioner has been convicted of a crime. There are some restrictions on people serving if they have been convicted of a serious crime. So it's something that you want to suss out with your client in advance before you submit this petition. If there's anything that the Register of Wills is going to encounter if they do a case search for your client, and you don't want any surprises. Opening an estate via judicial probate, and again, judicial implies the involvement of a court. If a petition for administrative probate is incorrect or incomplete, you might need to go via judicial probate. If you have a photocopy or a damaged will, you might need to go via judicial probate and ask a court to decide certain things. If you have a lower priority applicant for appointment and you don't have the consents of the higher priority applicants, you might need to go via judicial probate. So just in the example of the granddaughter, you represent a granddaughter, she lives in grandma's house, she needs to become the personal representative, and she needs to get the house into the name of somebody who's alive in order to qualify for homestead tax credits or get any grants for repairs to the house. She needs the consents of the people who are higher priority. She needs the consents of grandma's surviving spouse or children. And if there is a child whose consent she cannot obtain, she'll need to go via judicial probate to be appointed as a personal representative. Doesn't mean that she won't be appointed. It just means that you need to ask a court to overcome the lack of consents at the higher levels of priority. So you need everything that you otherwise need for administrative probate. You still need the petition for probate, the list of interested persons, the Schedule B or Schedule A, the death certificate, and the costs and fees. But in addition to that, you will be asking the court to overcome some deficiency in the filing, and the court will, the law requires publication of notice of the judicial probate proceeding, and so the hearing has to be scheduled 3 months out so that the publication can be made in sufficient time that people who believe they're interested can make arrangements to make it to the courthouse. Section 8105 of the Estates and Trust Code, I think, provides a roadmap for small estate administration or estate administration of estates that have a risk of becoming insolvent. This is the order of payment in an insolvent estate, and I refer to it often as I'm administering estates so that I don't get in trouble by advising my client improperly on making payments out of order. So this is order of payment in an insolvent estate. It's an enumerated list in the code of the people who have priority to be paid by estate assets. And we're just going to walk through these so that you can see how it serves as a roadmap for estate administration. And I recommend referring to this regularly as you administer estates, just to make sure, as I say in the margin there, that you can avoid any complaints against you and potential serious liability for making payments out of order. The first on the list is the fees due to the register. Now, as you know, I've already mentioned, the Register of Wills has to keep its doors open and its lights on and has to collect money in order to do that. So the Register of Wills is very interested in making sure it gets its money. The probate fees, the fees due to the Register of Wills, are the highest priority payment in an insolvent estate. Here is just a chart of small estate probate fees. It's something to be aware of, but I assure you the Register of Wills will tell you exactly how much you owe in probate fees. So you have a chart to refer to, and it's in the sample accounting as well, but the Register of Wills will keep you on task with that. Costs and expenses of estate administration. The number 2 on the list are things that come up in estate administration. This would be the bond, for example. If somebody's had to come out of pocket $100 to get a bond, they are entitled to being reimbursed from the estate for the cost of that bond, or photocopying costs, or the cost of death certificates. These are costs that come up as part of estate administration that are entitled to the second highest level of priority of payment. The third on the list is funeral expenses, and this is a priority for repayment, as you can imagine, because it would be terrible if people were paying for funerals and then couldn't get reimbursed out of the estate for those payments. So it's a priority payment. You must be aware of some of the basic rules, because as part of opening an estate, generally you have to provide evidence of the payment of the funeral, and you have to keep track of who made what payments so that you can reimburse them from the estate. Reimbursement for funeral expenses should be made within 6 months, and as of 2012 through the present, reimbursement of funeral expenses can include the cost of the funeral, the burial, the cremation, memorial service, wake, and food, also known as repast or Shiva food. Prior to 2012, those food costs were not reimbursable from the estate unless the will specifically mentioned it. So when you go to open an estate for a pro bono client, one of the first steps is getting the funeral expenses, and if your client doesn't have it, you need to Google the obituary of that decedent, find out what the funeral home was, and go to the funeral home and get as much information as you can about the paid invoices, because the Register of Wills will want to know that. This is a petition and order for funeral expenses. A petition and order, let me just go back here. You don't need a petition and order unless the estate is insolvent, or It's a little complicated. A petition is not needed if costs are below $15,000 and the estate is solvent or the will excuses the filing of the petition. If you have an estate that you expect might be insolvent, you'll want to look into this more and touch base with the register to see how just to make sure that you're getting the proper orders, so that they don't fuss at you when you go to file an administration account. This is the petition and order for funeral expenses. It has the petition at the top. I hereby request allowance of funeral expenses, and the order at the bottom. So this is a one-page way for the court to approve excessive funeral expenses. Fourth on the list, because the bar has a strong lobby in Annapolis, fourth on the list is compensation of personal representative and or attorney's fees. So if you are assisting with the administration of a regular estate, again, that is an estate that exceeds the small estate value, and that is $100,000 or $50,000 at this point, you may be entitled to attorney's fees in lieu of a personal representative's commission, or the personal representative may be entitled to a commission. With the pro bono cases, through the Maryland Volunteer Lawyer Service, it is unlikely that there is money in the estate to pay a commission or pay attorney's fees. And of course, this is a pro bono case, so you're not seeking attorney's fees. But that doesn't mean the personal representative isn't entitled to it, and it is a conversation that you should have or be prepared to have. A personal representative who administers a regular estate is entitled to a commission, and the commission is calculated as 9% of the first $20,000 plus 3.6% of any excess over $20,000. So if you have a $100,000 estate, that could be a personal representative's commission of about $4,000. That's a substantial amount of money, and it's the purpose of the commission is to recognize the work that goes into administering the estate. If the estate lacks the cash to pay that commission, then it might be a conversation just educating your client and telling them that they're not going to get it. But there could be additional conversations involved about that. So you want to be aware of the commission and be able to talk to your client through. A small estate, there is no entitlement to a personal representative's commission of a small estate. So if you're administering a small estate, it's not part of the conversation. Number 5 on the 8105 order of payment in an insolvent estate is the family allowance. Excuse me. The family allowance is a payment set aside in statute 3-201 of the Estates and Trust article that provide a living allowance for a surviving spouse and minor children. From 2013 to present, the surviving spouse is entitled to a $10,000 family allowance, and minor children are each entitled to a $5,000 family allowance. This is money that's paid before the payment of creditors, but after the payment of funeral expenses, fees due to the register, costs and expenses of administration, and the compensation of the personal representative. The idea is you can pay this in a higher priority than waiting for general creditors, so that you can get the money of the family allowance out to the family more quickly, because general creditors have 6 months to file claims. Number 6 is taxes due by the decedent. Ricky's going to get into a more detailed conversation about income taxes, decedent's income taxes, fiduciary income taxes, but it is a priority on the order of payment in an insolvent estate, and it is always something you want to keep your mind on as you're doing estate administration. I'm going to skip ahead to all other claims. The claims are addressed in 8103. The statute of limitation for claims is addressed in Estates and Trust 8103. General creditors have only 6 months from the date of death to file any and all claims against the estate for things owed by the decedent. You might be familiar with other statute of limitations that are, say, 3 years or 7 years or 12 years. This is an extremely short and very protected statute of limitations, because as a matter of public policy, the legislature understands that settling decedents' estates and settling them in a way that can be relied upon is really important. So all general creditors must file claims against the estate within 6 months of the date of death, whether for things that are due or due in the future. This is a serious statute of limitation, and we rely on it frequently in estate administration. I'm sure my colleagues can give examples of contests to this, but the courts are very good about honoring it. One exception is that the Department of Health, the Maryland Department of Health, formerly known as the Department of Health and Mental Hygiene, can file a claim within 6 months from the date the final notice of the appointment of a personal representative is published. Way back about 10 slides ago, we talked about the pages needed to open an estate, and one of the things you need to do is file a page that provides notice of the appointment of a personal representative, and then the register goes and publishes that in a newspaper of general circulation. When that is published, that begins a separate statute of limitations for the Maryland Department of Health to file its claims against the estate. This is critical because many estates with tangled titles, many estates with deeds that weren't passed on the death of the owner 10 or 15 years ago, the estate was never opened. And so the general creditors, that period for filing claims lapsed 6 months after the date of death of the decedent. But the Department of Health has its own statute of limitations, and that is 6 months from the date of the final notice of the appointment of a personal representative. And that is published in Baltimore City, Baltimore County, in the Daily Record. In other jurisdictions, it's other publications. But you need to be aware that the Maryland Department of Health is sometimes the largest creditor of an estate, and they have a special statute of limitations that gives them more time to file a claim against the estate. At the bottom here, you'll note if a personal representative enters into a contract and backs out, the personal representative's creditor can file a claim against the estate within 6 months of the date the claim arose. So that is not the same thing as a decedent's creditor. The estate can have a creditor. For example, if the granddaughter has been living in the house and she becomes personal representative and decides that she wants to contract with a painter to paint the house, and she's going to have the estate pay for it, and then she backs out of that contract, that painter will have a claim against the estate, and that is a separate statute of limitations than the decedent's creditors. So that's something to be aware of. We just talked about the Maryland Department of Health has its own special statute of limitations for filing claims against the estate. There is a way to shorten that 6 months from the date of publication, and that is to send the Department of Health a letter alerting them to the appointment of the personal representative, and that means any claim has to be presented within 2 months of the receipt of the letter. So here is a sample of that letter. We send it in all of our estates, whether we expect the Department of Health to file a claim or not, because the Department of Health is they provide millions of dollars of care to people, indigent people in Maryland through nursing home care or through payment of health insurance premiums, and they keep track. And when that person dies, they want to be reimbursed to the extent possible, and they will come out of the woodwork and get you. So one defense of an estate against a possible claim by the Maryland Department of Health is to send a letter notifying the Department of Health of the publication of the notice of appointment of a personal representative, and that gives them only 2 months to turn around and file a claim. By way of example, I'm administering an estate right now where mom died in 2007. One of the daughters has been living in the house since then, and so that's 13 years. And the house had a flood last year, and the daughter's been paying on the homeowner's insurance in the decedent's name for the last 13 years. And the flood caused a homeowner's claim. The homeowner's claim resulted in a check. The check is payable to the decedent, and there's no one who can cash that check. So we have to open an estate in order to negotiate the check, and the decedent's been dead for a long time. There are no general creditors who could come forward at this point, but the Department of Health could always come forward to file a claim. And we sent this letter in September of 2019, and in January of 2020, the Department of Health filed a claim. And the claim is for more than $20,000. It would wipe out the value of the house. But because we sent this letter limiting the Department of Health to 60 days to file a claim, we are able to disallow that claim, and the Department of Health will not be able to be paid from the estate. So you get to wear a little superhero cape when you do something like that, because it can really make a difference in the ability of a family to remain in that house. My pro tip here is advise your clients early and often that they cannot make distributions or receive distributions from an estate until you are absolutely assured there are no creditors that are going to be coming forward. The Department of Health has that special statute of limitations. They are tenacious in arguing that they are entitled to be reimbursed for certain things by the estate as a creditor, and you want to make sure that that you are free of any creditors' claims before you make distributions, because that can come back and bite you. If somebody files a claim you suspect is not legitimate, then the personal representative can disallow the claim through a notice of disallowance form. The effect is to require the claimant to file a petition for the allowance of the claim and to demonstrate to the court, the orphans court, the circumstances supporting that claim. This is the notice of disallowance form, and it says your claim has been allowed in this amount and disallowed in this amount, and your claim in the amount disallowed will be forever barred unless within 60 days after the mailing of this notice you file a petition for allowance of claim. So if there is a claim on the docket, and let me back up for a second, even if you have an old estate that you're opening, 10 or 15 years later, there could be a claim already filed with the Register of Wills, and it could be timely filed. And when you open an estate, it attaches to the estate. So there could be claims that were timely filed 10 or 15 years ago that only attach to the estate when you're open, when the estate becomes open. And if you don't believe it's a valid claim for whatever reason, you can notice a disallowance to the creditor, and then they're forced to file an allowance of claim and prove before the court that they have a legitimate claim against the estate. That starts its own separate 60-day statute of limitations for the creditor to then turn around and file a petition for allowance of claim. And if they don't, their claim is forever barred. So now, just turning back to our roadmap for administering an estate to Estates and Trust 8105, the order of payment in an insolvent estate. Fees due to the register, costs and expenses of administration, funeral expenses, compensation of a personal representative, family allowance, taxes due by the decedent, reasonable expenses of the last illness of the decedent, rent payable by the decedent up to 3 months, payments for services performed prior to death, repayment for public assistance to adults program, and all other claims. If you've walked through this roadmap and you have exhausted these and made sure everybody is paid, you may be ready to distribute an estate, which is great. That's what people are interested in. As much as we love our loved ones during their lifetime, I've got bad news. When somebody dies, it's all about the cheese. So people are anxious to get their distributions. You want to make them wait until everybody has been paid in the proper order. But once that's happened, then we can start talking about distributions. We're going to revisit the inheritance tax. Here, again, the inheritance tax is a 10% tax due on the receipt of a gift from a decedent or as a result of a decedent's death. So the inheritance tax in Maryland has a long history. I'm not going to go through the history in excruciating detail, although the Register of Wills will do that with you if you are administering an estate and they believe they're owed money, they will tell you. But I just want to give you an overview of the way the inheritance tax has changed over time so that you can be aware that if you are opening a stale estate, for example, if you have a decedent who died in 1997, and you're opening an estate because you're helping the child or grandchild get the property into his or her own name, you will need to be aware that the inheritance tax may be a question that comes up. So toward the top of the screen, you'll see direct or lineal heir. That includes, the definition includes a spouse, child, grandchild, great-grandchild, parents, grandparents, and stepchildren. So these are people sort of in the direct line up and down the family tree. From 1935 till 1999, the middle of 1999, those people owed a 1% tax on receiving a gift as a result of a decedent's death. From the middle of 1999 to the middle of 2000, they owed a 0.9% inheritance tax. But since July 1st of 2000, those lineal or direct heirs have owed no tax, no inheritance tax. So for the last 20 years, there's been no inheritance tax on direct or lineal heirs as included in this definition. Collateral heirs, on the other hand, which includes siblings, nieces, nephews, aunts, uncles, cousins, and includes friends, coworkers, other people whom you might leave a gift on your death. Collateral heirs, there continues to be an inheritance tax. For very old estates, you'll see 1874 to 1908, 1908 to 1935. Hopefully you will never encounter estates that old. 1935 to 1975, it was 7.5%, and then 1975 to current is 10%. That's more likely to be the inheritance tax that you encounter because that is 45 years of estate administration. It's a 10% inheritance tax. The important thing to note is that as of July 1st, 2000, siblings are carved out of that collateral heir category. So as of July 1st, 2000, no inheritance tax is due by siblings or direct and lineal heirs like spouses, children, grandchildren, etc. If you are administering an estate and there are gifts that are being received by people who are cousins or nieces and nephews or friends, you need to be aware of that 10% inheritance tax. There are exemptions to the inheritance tax. For example, life insurance passes to the recipient without being subject to inheritance tax. And this is important from an estate planning perspective. If you are helping somebody plan their estate, you can help them mitigate the impact of those taxes on the people they care about by doing some inheritance tax planning techniques. But for an estate administration for the last 20 years, if you have a decedent whose date of death falls within the last 20 years, there's no inheritance tax due for siblings or direct/lineal heirs. Now we're going to talk about actually getting property out of the estate and into the name of the new owners. And isn't this really the purpose of estate administration? This is where all the fun happens. Loved one dies and it's really sad, but maybe you get a little money out of it, or real estate. First, the personal representative is vested automatically with title to real property. That happens automatically by statute. When someone dies, their personal representative has the ability to control the real property. A personal representative's deed cites satisfaction of administration obligations, and Ms. Lambros will be getting into this in more detail. We'll just walk through one example here. But when you recite in your deed that you have paid all the death taxes, the estate has paid all the death taxes, you want to make sure that that's accurate. The deed will recite how the property is held by the new owners. If somebody dies intestate, the new owners, if there's more than one new owner, they're going to be tenants in common. If somebody dies testate and the will says, I want my children to own this property as joint tenants with rights of survivorship, then the deed is going to recite that the deed is going to recite that the new owners are joint tenants with rights of survivorship and not tenants in common. And a personal representative's deed is exempt from transfer and recordation taxes. If you've done other real property work, you know that the jurisdiction extracts a tax when you transfer real property, and it's based on the amount of consideration. When you're passing property out of an estate, the property is exempt from transfer and recordation taxes. So you have the resource of the, let me just switch back to that here. You have the resource of the sample guide for filing accounts. This is on the Register of Wills website. It walks through what an account includes, and then it walks through examples of an account. So you are never filing blind. You always have samples available to you online. You always have the resource of people, paid staff in the Register of Wills office who can answer questions for you. The employees who review accountings before court approval are called auditors, and auditors are a great resource for how to prepare an account or how to handle a particular asset on an account. You're never doing this alone. So you have that sample guide on the website for the Register of Wills, but I just want to show you an accounting that I did that has a little bit of nuance to it, and I don't want to take credit for this, I'm sorry, an accounting that I worked with my paralegal on, because I didn't personally prepare this accounting, but I did get into the weeds with the proportion of the house that is being distributed, because in this scenario, we had a decedent who died. He was married. He died intestate. He was married, and he had 3 kids, 2 kids with his current spouse and 1 kid with a prior spouse. So this decedent died with 4 heirs at law, spouse and 3 children. And his spouse, as we'll jump back to that list of interested persons, his spouse was not only the person seeking appointment as the personal representative, but also an heir. His children were heirs. And this estate stands out because it was house heavy and light on other assets. The decedent died owning a house, but not much else. He had a couple of cars and some tools. And we had to figure out how to pass the assets out of the estate while honoring the spousal allowance, which at the time of this decedent's death was $10,000, and the spousal preference. You'll recall from the state of Maryland's estate plan for you, if you die with a spouse and adult children, your spouse is entitled to at the time of this decedent's death, $15,000 plus 1/2 of the residuary. So toward the bottom right of your screen, you'll see in this matter, the spouse received $125,071.33, and that was comprised of cash, car, and a portion of the house that made up the allowance and preference, that $10,000 spousal allowance and the $15 spousal preference, and then the portion of the house that comprised 1/2 of the residuary. So the spouse, which rhymes with house, the spouse received $125,000 of the $225,000 estate, and then each of the children received 1/3 of 1/2 of the residuary, and that was comprised of a 15.25% share of the house. So we had to break down the assets in order to satisfy the spouse's greater share and transfer the real estate to represent the children's lesser shares. And so the deed ended up looking like this. First, we recited that the decedent died without a will in Anne Arundel County. On the date of his death, he was vested with title to the real property. His wife was serving as the personal representative. And in that 4th paragraph with the arrow, it says the personal representative duly conducted proceedings concerning the decedent's estate before the Register of Wills, paid the requisite death taxes, and filed a final administration account approved by the Orphans Court order dated August 8, 2017. So we are reciting in the deed that our personal representative has crossed all the T's and dotted all the I's in the estate administration. And the top paragraph here, this is just a prelude to some estate planning tips and tricks that Ms. Lambros will go through. This decedent received this property by virtue of being a remainderman on a life estate deed. So his mom had the foresight of avoiding probate by using a life estate deed, but he didn't even do an estate, and he didn't even do a will. So instead, here at the red arrow, his spouse and children are going to be owning this property in these interests. His spouse is going to have a 54.25% undivided interest, and each child will have a 15.25% undivided interest. And I can assure you that in the conclusion of the estate administration, and in fact, several times since then, I've reached out to this surviving spouse and begged her to do her own estate planning, because this has the potential of being a real disaster. When she dies, her share, if she dies intestate, will be further divided to her heirs at law. So do a will, it's important. Ms. Lambros will get into that. The State of Maryland Land Instrument Intake Sheet, you may be familiar with this. If you're not, it is just a thing of beauty that you can find on the internet. The State of Maryland Land Instrument Intake Sheet that's good for every jurisdiction except Baltimore City. And you'll see here recited the exemption, the code sections exempting personal representative deeds from recordation and transfer taxes. So before you close the estate, you want to make sure you paid all the fees and reimbursed any advances. You want to make sure you've waited out the creditor period, shorten the creditor periods where you can for the Department of Health. You want to wait out any 60-day limitations begun on the service of a notice of disallowance of claim. You want to make sure your funeral creditor is fully reimbursed, pay any allowances due to the spouse or children, and pay all valid claims. You want to do all of these things to keep your nose clean, keep away from any attorney grievance or lawsuits related to bad advice that you might give your clients. So you want to hold their feet to the fire so that you can sleep well at night. The Register of Wills has sample guides for the sample guide for filing accounts. It has been updated, so the handout that you have differs slightly from the one that I'm referring to on the website itself. This was updated and in 2020. So you'll see here on the website, the sample account was updated in April of 2020, and I did not get a copy of that over to MVLS in time for this presentation, but this is on the Register of Wills website, so it is always available to you in the most up-to-date format. It includes the summary of the funeral expense limits for historic estates and estates in the last 5 years, summary of family allowances, the regular estate probate fee guide, examples of calculating commissions, summary of intestacy distribution schemes. In other words, that's the State of Maryland's estate plan for you if you don't have a will, and the summary of historic rates, allowances, and exemptions. Sometimes tangled titles in estates involve opening old estates to accomplish sorting out the title for people going forward. And so sometimes you will have to be aware of the historic rates, allowances, and exemptions. And the purpose of this talk is just to make you aware of it. The Register of Wills website, but also the deputy registers, the auditors, the new probate proceedings, they're all a tremendous resource if you are in the position of opening an estate like that. And of course, you have your attorney mentors through MVLS if you are in that position as well. That concludes this portion of the talk, which is an overview of estate administration. Mr. Adams and Ms. Lambros are going to dive into some details, but I'm happy to take any questions. It looks like I am running ahead of schedule, which nobody ever complains about. So if I can answer any questions, I'm happy to.
All right, thank you, Alice. So it looks like we do obviously have a few questions. So the first question is, so when there is a will and there are heirs of the decedent at law who are not legatees, but are initially considered interested persons, should a new list of interested persons be filed without them on it after they have been served notice of the opening of the estate?
Can you read that again, Tim?
Okay, so when there's a will and there are heirs of the decedent at law who are not legatees, but are initially considered interested persons, should a new list of interested persons be filed without them on it after they have been served notice of the opening of the estate?
It's a great idea to do it. You can do it. You should do it. Does it happen all the time? No. But yes, you can.
Okay. So our second question is, so what do you do when the spousal allowance and the residuary is less than the value of the only asset, for example, a house in the estate? So the decedent died, leaving a spouse and 2 adult children.
So and it's a house, you said.
Yes.
The ultimate arbiter of distribution is the orphans court, and the orphans court will issue an order approving an accounting, and the accounting will show what you intend to distribute, how you intend to distribute it. In that instance, and my colleagues may have a different answer, but the priorities there are the spousal allowance, the reimbursement of funeral expenses, and that could exhaust the assets of the estate, in which case the title of the house is going to be to either the funeral creditor and the spouse, or the spouse as compensation for the spousal allowance. But ultimately, the easiest thing to do is, if the children agree, then everybody signs a piece of paper that can be presented with the final administration account saying the spouse is getting the house. And we all understand that, all the interested persons understand and agree that the distribution is to the spouse. Even without that piece of paper, mathematically, the title of the real property will end up in whoever's owed the most money, which is often the spouse.
Makes sense. And I actually have a question myself. So you mentioned earlier there being personal representatives bonds and nominal bonds. So is there like any discernible difference between the two bonds, the two types?
Oh, is there? Is there ever? Yes, so a personal representative's bond is a bond that protects not just the creditors of the estate, which include the register of wills and any creditors who file claims, but also the people who are to receive from the estate as legatees or heirs. A nominal bond protects only the register of wills and the creditors of the estate. That's why it's cheaper. So a personal representative's bond protects the gifts or distributions that would be coming out of the estate, and it's more expensive because it is supposed to, well, let me step back and say different registers address bonds differently. So a personal representative's bond covers creditors, the register fees and expenses due to the register of wills, and legatees or potential distributees. And so some registers of wills or orphans courts will impose a personal representative's bond in the amount of the assets expected to pass through the estate. And that's the amount of the assets listed on the Schedule B or the Schedule A for a regular estate. And so if a regular estate, for example, has a house worth $200,000, that house is listed on the Schedule A. When you go to open the estate, the Register of Wills will ask for a personal representative's bond in the amount of $200,000 for the PR in a regular estate. There are forms that can be signed by all interested persons to waive the need for a personal representative's bond. And in that instance, the court will impose a nominal bond, probably in a smaller amount. Some courts impose a nominal bond in the same amount of $200,000. A will has a lot of functions, but one of the functions is that it can excuse the executor from the need to post a bond. And what that does is serves the same purpose as those consents, which is it tells the register, don't impose a personal representative's bond. You can impose a nominal bond. And a nominal bond, again, is cheaper. It covers only the creditors and the register of wills. So you can do that by will, by saying in your will you don't want your personal representative to have to serve subject to a bond, or by filing consents of all the interested persons saying that they excuse the need to impose a personal representative's bond.
All right, thank you. And thank you for your presentation. It was very informative, very lots of resources, lots of knowledge here. I'm very happy to have you here today. But thank you. So since we are running a bit ahead of schedule, we can actually we can insert a quick break for people to run to the restroom if they need to. Well, actually, we have one last question, sorry. Okay, so the last question is it your opinion that one should not distribute assets until the creditor period is over?
Without a doubt, that is my opinion. If you and my colleagues, I'm sure will speak to this as well, but if you make distribution prior to the expiration of the creditor period, you're exposing those legatees or distributees to the potential of having to pay back to the estate in order to satisfy the claims. And it really upsets people a lot when they've received something and they have to give it back. And it upsets them when they've received something and other people have received the same amount, but they have to turn back their full amount and somebody else doesn't, for example. You want to be as conservative as possible, allowing your creditors' periods to expire. And again, there are two separate periods here, and that's the terrifying part. If you are not accustomed to, if estate administration is not a big part of your practice, there's a 6-month general period for creditors, and that's important to be aware of. It's so easy to calculate. You just count on your fingers 6 months from the date of death. It's that second 6-month period from the date of the publication of notice of appointment of a personal representative that the state of Maryland has to file its claims through the Department of Health. Those claims are not only can be very expensive, hundreds of thousands of dollars if your decedent spent time in a nursing home, but also the state of Maryland has limitless resources to relentlessly pursue payment of those claims. So the best course of action is to advise your clients and the heirs at law that the estate simply cannot make distribution until these periods have passed and you are absolutely assured that there are no creditors.
All right, thank you. Okay, so since we are running a little bit ahead of schedule, we can take a brief break for people to run to the restroom, get any water, coffee from their homes if they wish to do so. So let's convene at, let's just say 10:35. So the next presentation will start at 10:35. All right, welcome back. So our next presenter is Richard Adams. So Richard's practice focuses on elder law, Medicaid planning, and estate administration. So we are very lucky to have him here this morning to provide guidance on navigating some of the more common issues that arise for our volunteers and our clients. And with no further delay, I'm going to pass the reins over to Ricky.
Thank you, Tim. Can you hear me okay?
Yes, we're all good.
All right, you can see the screen okay?
Yes, yep.
Excellent. I must apologize. We have a kitten, and she has been my coworker since the pandemic began, and you may hear her trying to destroy things in the background, so I apologize. Thank you, Alice, for that wonderful presentation. I've had an opportunity to hear her presentation in the past, and it's very thorough. And I love all her resources, along with Cristin's resources that they put together today. So I hope everybody has a chance to look them over later. I've used Alice's materials in the past for my own cases. It's very practical. I do want to go through one extra thing that I've thought of as she was going through some of her aspects, was one of the exemptions for motor vehicles in Maryland. So a lot of clients back in the day, you had to open up a small estate just for a motor vehicle, because often that would be the only thing in the deceased spouse's estate was a car. So Maryland now has an exemption where if that is the case, they can now process and distribute that car to the surviving spouse if they meet certain requirements. For example, if that's the only thing in the estate and there are no debts. So I'm going to send that statute over to you, Tim, to provide to the volunteers, because that might be helpful for them.
Thank you. I will pass that on.
Excellent. Otherwise, this presentation is going to just go over some practical tips. It'll definitely refer back to some stuff that Alice has talked about and some things that Cristin is going to talk about later. But we try to incorporate some things that come up a lot and provide you with some guidance for some of those issues. So I wanted to kind of briefly go over the powers and duties of the PR, dealing with heirs, which is always fun, and also dealing with the estate creditors, and then modified administration, which has its pros and cons as well. So one thing I wanted to talk about here was the PR. So they have a fiduciary duty, as stated under the last will and testament, or under intestacy, as Alice explained. You had to follow the law, you had to follow the will, and basically process the estate as quickly as possible, considering all the various issues that come up, while also considering the interest of all the interested persons and the creditors. And as Alice talked about, especially the creditors, often what will happen with a client is that they'll pay a bill because it arrives, and meanwhile there's another creditor out there, and not realizing that they've actually treated them differently. And so that's one thing, one of the first things we talk about with a client when we meet with them is kind of set like the rules. You don't want to do that. Talk to the attorney to figure out how to administer the estate. Some practitioners will assist them with maintaining the checkbook of the estate account to kind of mitigate that. But I've seen that a lot where they've treated different creditors in different ways, and it doesn't go well because creditors don't like that, obviously. And really, they shouldn't be doing that anyway. And of course, one of the big issues today is the real estate. That's what we're kind of focusing on in this presentation. And often, especially in my clients in Baltimore City, the real estate is the biggest part of the estate. There are so many issues, with the clients in Baltimore City and Baltimore County that hopefully this presentation will be a great tool for you as you work your cases. We have to deal with potentially dealing with tenants, rental property, evicting people from the property, and then coordinating the sale of it too if the heir wants to sell it. It can be very complex, and I know Cristin is going to have some great forms and resources to deal with a lot of those things as well. I do want to start with a story of a client I had recently where they didn't have good planning, as Alice talked about, and it was a piece of property in Baltimore County. The mom was the decedent. She was on the property. She had listed her daughter and the daughter's husband, so they owned a share as tenants by the entirety. And then she convinced the daughter to add the son to make it fair as a tenant in common. And mom owned her share as a tenant in common. And so you can imagine the problems when mom died, and she had no will, of course. The daughter had meanwhile paid the mortgage. The daughter was living in the house with the husband and mom, and the daughter had basically maintained upkeep and all the expenses of the house. There was no agreement with the son to contribute. And so when mom died, the son called up the daughter and said, "Where's my portion? I want my piece of the house." And it was a terrible case, and the daughter was kind of stuck because there's no agreement, and that's how the property was titled. And so she sold the house and had to give him, his portion of the proceeds, not only as the owner because he owned a share of the property, but as an heir of the estate because there was no will. And so he got paid, twice, which the daughter to this day is still resenting. But the problem is that's how it was titled. And so I hope that kind of frames how terrible these issues can be without proper planning. So that takes us to dealing with heirs. So we have heirs and beneficiaries, and like anybody, they can be friendly, understanding, patient, and then quite the opposite, as Alice had also talked about. My role is, and even in that case I just briefly mentioned, is to treat people with respect. The son in that case had an attorney, and the attorney was great, but he wanted to get the maximum return for his client, and he was quite aggressive in negotiating for the percentage that should go to the son. And you just have to be mindful of the rules of professional conduct. I made sure to confirm everything in writing, especially when dealing with unrepresented parties. A lot of cases I've had with MVLS, with lower income clients, often the client doesn't even come to you and to MVLS until some things have already happened. Some of the personal property has been taken from the house, for example, or they're not necessarily telling you the whole story. And so a good part of the intake and following up with the intake when it gets to you is to confirm all that. And as Alice talked about, review the records, confirm, where is the personal property? Okay, what happened to the wallet of the deceased? What life insurance policies exist? I've had heirs, the keys are stolen from the house and you can't get into the house because the person who wants the house has stolen them. And so we've had to take them to court to get a court order to give us the keys. And, that's a very time-consuming process. But a lot of these smaller estates have expensive issues related to them because of these things, because the decedent trusted perhaps the wrong person at the time. And so usually, I try to be collaborative, and I definitely recommend that to you. And also, pull in people that can help you with some of these issues if you don't have the background. So some things I'm going to talk about relate to evictions, which is like a litigation action, basically. And I'm not a litigator. And so when I've done them, I was at a firm that also had a litigation department. So I was able to use those resources. And so I recommend, same thing with the MVLS cases. There are, Tim and his staff can help you find another volunteer to assist you with those aspects of the estate administration. And that way you have the resources you need available. It's not expected that all of these different, very nuanced aspects of the law, because that's really just not possible, I think, and to do it well. And same thing with a lot of the tax controversy issues. Those are very nuanced. It can be very complicated. And Janice and her team at MVLS kind of had the tax group, and I'm sure would be a wonderful resource for all of the volunteers related to estate issues and the taxing agencies. So I just say never be afraid to reach out for help. And that also includes dealing with the registers, as Alice touched on. If you have a question, call them. And I still do that now. As she said, a lot of them handle estates very differently. For example, Anne Arundel County, they require a higher bond amount than Baltimore County. And so, when I open up an estate in Anne Arundel, I always call them to confirm it's still 25,000. Okay. Because for some reason they have a higher limit, and if you open it with a bond that's less, they will not accept it. You'll have to get an amendment to the bond, another bond. And so just don't be afraid to ask for help. And I found that the register staff are very open to helping. I think they prefer for you to reach out before you've done something, because it's easier for them to help you and to deal with it. That's been my approach anyway. So locating heirs, and that's always fun. I think part of this goes back to intake issues, right? So do you have the information on the decedent? Who has reached out to you? Is it a neighbor? Is it a friend? Is it the spouse or the child? We had an estate once where we had done the father's estate, and then the mother passed away, and probably 10 years after the fact. And the daughter came to us and said, "Oh, I'm the only child. He didn't have a will. Here's the stuff." And so when we look back in the file for the father, we had filed a list of injured person for the father, and there was another son. There was a half brother, which she forgot to mention when she met about the mom. And it turns out he was alive, of course. And the daughter's like, "Oh, I didn't even think about it." And it's like, how could you forget about your half brother? But okay. And of course, then her distribution from the estate was half what it would have been. So you just have to double check, even if they're telling you what it is. You have a duty to advise them and to use the resources available. So as Alice talked about, mail-in land records, you can get a free account. It's very easy to use, very organized. The different counties have some different search items. Like Baltimore City, you could find it based on the address, whereas in the other counties, you're filing it based on the based on the name of the person. And so that may not be as easy to find, because often those records, a person may have entered them. There could be a misspelling. So you may have to put some time into that, but you can pull up the deed and you'll have access to that information and kind of follow the line of title as you need to. SDAT itself has the tax records, depending on where the property is located. You can certainly look up local tax records, which can be helpful, like in Baltimore County and in jurisdictions outside of Maryland. Of course, each one is different. Accurate through LexisNexis I used to use at my old firm, and it was very helpful in pinpointing where a person is. We used it a lot. We also did creditors' rights to find debtors, but there was a fee for it. I'm not sure MVLS may have access to something similar, perhaps, but it was helpful in identifying exactly where someone was now, which, with all our technology, it's almost easier to hide. We used to use Facebook. We'd find someone on Facebook and Instagram, which seems kind of crazy, but I guess you have to use the tools that you have. And then the Maryland Judiciary Case Search, of course, which is helpful to find, tax liens are available that will help you to identify if the IRS or the comptroller could be a potential creditor in the estate. The lien will be listed there. And potentially there'll be something filed in the land records against the property. And of course, obituaries, which is always helpful. And then usually when you open an estate, you'll get a piece of mail from, companies, private search firms that will help you find heirs, such as heirsearch.com and things like that. So you have a couple different resources that should help you to kind of put together the puzzle. And as Alice said, you have to use that natural curiosity, and it's kind of like you're a sleuth and you're trying to find the truth here. So uncooperative heirs. So I've found that emotion is fueling a lot of this, and it could be that the heir honestly doesn't know, right? So like the example of the daughter, perhaps she didn't mean to be, deceitful. She just didn't realize the brother was alive, perhaps. But or they should think, "Oh, I should get the house." So in that same example, the decedent had a girlfriend who lived in the house, and we also had to evict her. So it was a really fun case. But in her idea, the house should go to her because she lived in the house with a boyfriend for like 20 years, or it was like 10 years, I guess. And he always promised her, allegedly, that she would get the house when he died. The problem was he had no will, and the house was titled in his name alone, and he didn't actually take the steps to ensure she would get the house. But in her view, it should go to her. And so when we took her to court to evict her, she did show up, and that was her argument, was that he intended to give her the house and it should go to her, and she was the grieving girlfriend. And it was a very uncomfortable and litigious situation. And so it's just an example of how emotion and, belief, perhaps mistaken belief, can kind of fuel all these problems. So to mitigate that, I always recommend that, keep lines of communication open, send things in writing, send letters, because people will often forget, some of the details you mentioned on the phone, or they'll, change their understanding of it later after they've talked to somebody, a friend, or done some of their own research online as to how this should go, instead of realizing how the process really occurs. And, again, confirm everything in writing, and then have the heir sign a release. Under the law, the PR is allowed to require them to sign a release, which protects the personal representative from future issues. And I've included a form that I've used in this presentation. So I think that's all I wanted to talk about with those. And I do want to, I'm just kind of confirm what Alice talked about with the emotional connection. I've often found it's not about value, right? When you deal with heirs, it's about the principle, right? Well, he shouldn't have that. Mom said I should get it, and it's not right. And we've had lots of estates where that's what's fueling the problems. And I think you're in a special situation where you can help mitigate that because you're a third party, you're representing the estate, you're not representing, someone in their specific personal situation as an heir or beneficiary. And I've used that to kind of help, like say, look, talk to me and let's figure out what do you want? What's the problem? And then as Alice said, you can put together some sort of agreement with them to help make everybody, kind of agree on what to do. And then one other thing I wanted to talk about with preserving property, like in the example of the person stealing the keys, you may have to go to court and get the court to back you up to get access to the property of the estate. And then you can change the locks as long as there's no tenant in there who may have tenant rights. And often people want to store stuff of the estate themselves. It could be maybe it's not cost effective, especially with some of the estates that we're dealing with MBLS clients, to pay for a storage unit when a person who is trustworthy could store it for the estate. But if you do that, I recommend that you get something in writing, because the title is actually vested in the PR. The person is almost like an agent who the PR is using to secure the property, but the responsibility is on the PR. So dealing with creditors. So as Alice talked about, creditors, for the most part, have 6 months from the date of the decedent's death to file any and all claims. And alternatively, the PR can mail or otherwise deliver to the creditor a copy of the notice of appointment, notifying them the 2-month time period. And otherwise, the claims are barred. And Maryland has several cases that they've aggressively kind of protected this right, that they have a limited time to get these claims in. The PR also has the right to disallow the claim. So when a claim is filed, the PR doesn't have a certain amount of time to allow or disallow, right? They can kind of sit on it, see what happens, and consider whether or not it is legitimate. Now, I've found, especially with out-of-state creditors, if you file a notice of disallowance, the out-of-state creditor is going to have to file a petition of allowance to get it in. Otherwise, as Alice talked about, the 60-day period, once that's up, the claim is time barred. And so it may be difficult for out-of-state creditors. For example, creditors who, it's like the special, like they buy up the debt of credit cards, for example, like DNC or NCD, I can't think of the names, but usually they're like in California or Ohio, and they're not in Maryland. And so likely they're not going to hire a Maryland attorney to prepare such a petition. So if you do a notice of disallowance, that claim may go away because of that, because they don't have the ability to prove that the claim is legitimate. And so that's one thing to consider, is depending on what the claim is, it kind of gives it to the creditor to prove that the claim is valid. And the PR has the authority and the right to do that. And so that may be a recommended avenue to kind of get rid of some of these claims, especially if there's an option that it is not legitimate. And so the notice of creditors is only required if the estate assets are in excess of the fees owed for the administration. So like as Alice went through that list, the register fees, any appraisal costs, the funeral expenses, and the family allowances. So for example, in a lot of small estates, and in regular estates where there's those fees will eat that up, you don't actually have to publish notice. Now, the reason you may want to is kind of what Alice got into about the Maryland Department of Health. So and I liked what Alice talked about was of sending that letter no matter what, because it could be that no matter what good research you do, no matter what records you find, there could potentially be a claim out there for Medicaid. And Medicaid is going to aggressively assert that claim and use all they can to get paid. And many of the estates I've worked with MBLS have had claims like that, where the state didn't have to file the notice because of this limit, and so they didn't. And then here comes Medicaid later asserting their claim and saying, well, you never gave me notice. And so their claim is timely, even if it could be a year or two down the road, because you didn't actually trigger the notice requirements. Medicaid is still able to file the claim. And so perhaps it's a good practice to file the claim anyway. I'm sorry, to file the notice anyway. One problem could be, as Alice mentioned, the costs, which can be prohibitive. It could be, with the daily record, and I believe there may be some assistance you can get through MVLS, but like a regular state is like $112, and I think a small state is like $62, and that could be money that the client can't afford to pay. That's same thing with the bond. They don't always have $100 for the bond and $112 for the notice to publish. And meanwhile, that could cost them the whole house value later if they don't file it. And so I think you have to balance that out and see, is it worth the risk, or should we just publish notice, maybe borrow money from a friend, or figure out some way to get the money to file the notice, and then mail that letter, that form that Alice provided, and that way you can know in that 2-month period, you've kind of dodged the bullet in the event that there is one. Otherwise, you may wonder, as Alice said, Medicaid could come back at any time, and often, as we've seen, a lot of the estates in Baltimore City, we're talking about really 2 estates, like grandmom died, mom lived in the house, mom never did grandmom's estate, mom dies, and so you had to process it through both estates, and it could be they both have potential Medicaid claims, and neither of them have published notice. And meanwhile, the daughter's living in the house, and so that just has a host of problems that we would like to avoid. So I'm going to kind of talk about receiving correspondence from a creditor. So again, like the credit cards will send letters, will try to reach out, especially if notice is published and they're able to identify who the attorney is and who the PR is. Typically, a lot of them don't file claims, right? They'll send a letter, but they don't file a claim. And so I always, advise my client that you only have to pay the claims that are legitimate, that are filed. And so until they file a claim, we don't really have to consider it. And that's, kind of the truth, that it's on the creditor to do that, to file the claim. And then, work closely with the PR to ensure that all the claims are legitimate. And that could be when you kind of decide whether or not to do a disallowance. And that kind of puts the burden onto the creditor to prove that the claim is valid. So if the creditor does respond and they do the petition for allowance, what the orphans court will do is they will schedule a hearing, and that will allow you and the PR and the creditor to appear and to discuss whether or not the claim is legitimate and should be allowed. And then I always follow up with creditors in writing via mail or email after I talk to them, because again, they often forget what we talked about or change their story. And this kind of goes through the form, which I put on here, the disallowance form. And then alternatively, the PR can themselves petition the court. Let's say they don't know whether or not the claim should be allowed. We can ask the court to decide for us. And that way it's kind of off the plate of the PR. And then this talks about Medicaid. So again, they can place a lien on the house, which is based on whether or not they return home from receiving long-term care Medicaid. These are kind of the requirements, like if there is a disabled child living there, they cannot place it. If there's a spouse living there. And really, because I also do Medicaid applications, the lien is actually a second step, right? So if the person, let's say the house is still in their name, they're still in the nursing home after 6 months, Medicaid just has the right to place a lien. They may not have done that. And often I've seen where they don't. But so it's like a second step that Medicaid has to do to put that lien on there. And then the hardship, there is a hardship waiver. Basically, you would work with Medicaid to show that the lien shouldn't be enforced because, you know, this person is dependent upon there. They've lived there for so long, or, you know, they can't find another place to live. And that can be hard because, as Alice talked about, Medicaid wants this money. And it could be, especially, you know, under this, the current situation we're in, I think states and local agencies are going to try to get as much money as they can because they're going to be, you know, without money because we're trying to kind of deal with the economic issues we're going through now. And so they could be even more aggressive potentially once we get through these next couple months. And the hardship is a high bar, and that in itself can be a very stressful process. And if the factors aren't met, they can also place a lien, a non-interest-bearing mortgage on the property, basically. And that way, Medicaid can work with the dependent to pay off what is owed to them while allowing the dependent to still live there. And that way, it's kind of like a compromise. But not everybody could qualify for that, right? Not everybody could afford that. And then just talking about Medicaid's right to file a claim. And again, the same requirements, prohibitions relate to them filing a claim against the estate of the person. If there's a surviving spouse on the property, the child under the age of 21, or a blind or disabled child. And so if that happens, the PR should disallow the claim based on those circumstances. If there are insufficient assets in the estate to pay the claim, which is possible, because as Alice talked about, nursing home care is expensive. And if they've been in a facility for a long time, you could be talking about $100,000 plus bill, and the house in Baltimore City might not be worth that much. And so that could be a problem. And so this just kind of goes through the statutory language about Medicaid's special circumstances. I wanted to give you some resources. So COMAR here, this talks about how Medicaid treats these liens and the resources of applicants. So I figured that might be helpful. Another article about repaying nursing home, which kind of breaks it down a little bit better. And then DHMH, well, now the Department of Health, have this nice outdated form from back in the day, which I thought might be helpful to you. And I want to talk about the IRS. So as Alice talked about, tax issues are definitely something that comes up. Everybody, every client we have, we need to figure out, do they have an income tax issue? You have to at least file their final individual income tax return, and potentially the estate itself may have to file a fiduciary estate income tax return. The big issue, though, is if they have past due income tax problems. So if there are any liens on the house, when you do the research on the property, that will show you if there are potential tax problems if the IRS or the Maryland Comptroller have placed liens. Clearly, then there must have been a problem, and if those liens are still outstanding, you're going to have to deal with them. And it's not going to be an easy process. It can be very confusing. The IRS, especially now, they're overwhelmed even more so with the current situation. I think that will make it harder to get some of these issues resolved. And so what's actually subject to the IRS, the assessment of tax liability. And so the example would be if the assessments occur before they die, the assessment actually attaches to the property and it forms a lien. And so it could be that, if they, and again, the IRS has to make that assessment, right? That's one of the administrative things they have to do. And sometimes they're slow to do that. But if they do, it actually attaches to the property. And so when that property goes into the probate estate, or if it goes to the other beneficiary, it's still attached to it. It still has to be dealt with. One example I'll give you, a client I had was, we had a divorced couple. The husband owed taxes on the piece of real estate that they were supposed to have liquidated in their divorce settlement agreement. The husband and the wife failed to sell it though. And so when he died, the lien's still attached because when they divorced, and I'm sure Cristin will probably talk about this, the divorce severed the tenancy by the entireties and made it tenant in common. And so it attached to his share of the property, these liens. The wife, wanting to sell the house, has to deal with that, right? Because now it's going to affect what will happen to his portion. He didn't have a will. He had a couple of children. And so that's going to affect what they get from his estate. And it was just a real mess. Not to mention they both violated the settlement agreement. So that's a whole other issue. If the assessment occurs after death, then the assessment lien attaches to any probate property in the estate. So that kind of opens up, what's vulnerable, not just what would have been the property that would owe the tax, but the whole probate estate is vulnerable. And so that you have to work through that as well. So just the bottom line is the PR has a duty not to just file the simple income tax return, but they have to determine whether or not past due taxes are an issue. So there are forms that you can file that it's kind of like a power of attorney to get information from the IRS and the comptroller to get access to those returns. And of course, perhaps the PR or the family could give you copies of those returns if they have them in the records of the decedent. Often, though, if they haven't been filing returns and they owe taxes, it's kind of hard to piece that together. It's like a puzzle. And often the surviving family members may not realize that these tax issues exist until the decedent is gone. And so I treat the IRS basically as a secured creditor who has extensive authority and resources, and will try to maximize their return as well. And so just to touch base on the IRS, a final thought is, again, use the resources that MBLS has. Janice and her team who focus on tax controversies for MBLS, they should be a great resource. They can help you by working with a tax volunteer attorney to do an offer of compromise with the taxing authorities to get rid of, penalties and interest potentially. And they'll be able to work with you to resolve that. Because the problem is the estate can't be closed until those issues are resolved. And that's often, in my experience, what keeps an estate open longer are these tax issues. Even filing the last income tax return can be very time consuming. And so I wanted to now dive into the evictions. So often, PR will have to deal with a tenant or a squatter in a piece of real estate. And of course, currently, evictions are on hold. So I guess now is a good time to be a squatter because you can't really do anything about them. But I've often seen where in families, it'll be like a grandson. Grandmom let the grandson live there, and when she dies, what do you do? Because the grandson, he's not a beneficiary of the estate. Let's say she even had a will and given it to her kids, but he doesn't want to leave. And so now you have to evict, a loved one from the property, perhaps to sell it, for example. It just makes it very difficult and stressful for everybody. And so again, I would advise you to collaborate with an appropriate volunteer because the eviction process is not easy. It's very procedural. It requires you to do things in a very specific way. And if you mess up one part of that process, it kind of knocks you off kilter and you have to go back and do it again. I've had issues in Baltimore City where you had to do service to the tenant, and I think there were two different forms that Baltimore City had, and we did the wrong one apparently. And so they sent it back to us after we had served it to the tenant. And, of course, now they're on notice. We're trying to get rid of them. What are they doing to the property that they're living in? Are they destroying it? Are they doing something to it? And it just added additional stress to the PR. And it was stressful to the attorneys, of course. And then the example I started out with with the girlfriend of the decedent that we had to evict. She actually ended up, because it was such a protracted process, while we were working to evict her, she took all the fixtures out of the house and sold them on Craigslist. And she took all of the personal property she could and sold it. And because we couldn't get entry into the home, and it was just such a terrible situation for the client. And of course, the girlfriend, when she went to the court, because she showed up for the eviction hearing, said that, look, I'm the girlfriend, I'm grieving over the loss of my boyfriend, who had died of a drug overdose. And it was just such an emotional hearing then for the sister to have to go through with that as the PR. And the judge had sympathy for the girlfriend. She had lived there for a long time. Could we give her more time? And so she took more time, and then she continued to sell stuff from the house, which we didn't know until we got into the house, unfortunately. And so it just opened up a whole can of worms and gave her more time to do the things she wanted to do. So it is not an easy process. And so one of the first steps when you're doing the intake and meeting with the client is to figure out, is there a lease? Is there an agreement with the tenant? A lot of times it'll be oral or simply reflected by their actions, right? So in the case I'm talking about, the girlfriend paid rent. And so we were able to see through the bank records that once a month she was giving the boyfriend $400. And she said that was her rent. And then, again, collaboratively, try to work with the tenant, convince them to leave. We give them time to find a new place to live. You're trying to save money in the estate and having to go through this eviction, plus the emotional toll. Make sure when you're doing that, though, to make sure the letters and the notices you're sending are consistent with the notice requirements in the jurisdiction you're dealing with. So like Baltimore City, they have a different requirement than Baltimore County, and what the letter must say. Are you giving them notice and how long? It has to be a certain amount of time. Otherwise, you have to start over and do it again. And then they get more notice and more time. And I found it helpful that if you serve the tenant, use a process server. Don't just mail them a letter, have them served. And I believe MVLS may have resources to have a discount process server for their cases. And often that'll scare them enough to make them leave, honestly, because they see that you're serious about the eviction process. Because part of this is they don't believe you're going to do it. And so you have to kind of prove that, look, they've engaged an attorney. We're going to go through this legal process, and here we go. And so if the tenant still refuses to leave in good faith, that's when you should begin the eviction process. And then I listed a couple. Baltimore City has a great step-by-step guide to this. The Sheriff's Office in Baltimore City does as well. And then the Maryland Attorney General has a nice publication about different rights. But each jurisdiction is different. And so again, I recommend you call the court, get advice from the clerks. What do they need to make this as smooth as possible for you and for the client. And then for the eviction hearing, again, once they're allowed again, be prepared for the tenant to show up. Every client I've had to do this with has said, oh, they're not going to show up. And every time they've showed up. And so don't, be prepared and say, look, these are the reasons, this is what we've done. But because in their mind, they could get a house for free, right? This is the house they should get. And they are going to show up and fight for it. And so now I wanted to kind of go into a modified administration. It's a streamlined process. It doesn't require an inventory. It doesn't require an administration account. There's things that Alice kind of went through, because basically the people involved are not subject to the inheritance tax. And so the Register of Wills doesn't really need to monitor it as much because it's not as complicated. Usually you're talking about surviving spouse, children, perhaps people who are getting along, and they're going to divide up whatever's in the estate equally. Now, of course, the assets have to satisfy what's outlined in the will, along with the debts, but it's much more streamlined. It doesn't require as much work on the behalf of the attorney. It doesn't require, we don't have to show the gain or loss in the estate. And so one of the problems with it is that when you file the final report, it doesn't actually show what the actual distribution will be, right? Because it'll show the date of death value, it'll show the expenses, and that equals this number, which really isn't the real number because there could have been income, there might have been refunds, gain or loss on the assets. And so I always caution my clients, like, this is kind of like just a reporting requirement. This is really what you're going to get, and we kind of do our own like accounting for them. But it's just an easier method of processing things through probate because you don't have to have that oversight. So the election for modify must be done within 3 months. It's of the PR being appointed, so that gives you time to confirm, is there any inheritance tax issues? Will everybody get along? Will this work? And of course, you would have had to file the inventory within the 3 months anyway. So this way you can kind of do both and see what would work best for the client. And then the final report is due no later than 10 months after the PR has been appointed. So one of the difficulties is if you don't think the estate will actually be able to do that, because it has to be distributed within 12 months of the appointment. So like if you need to sell a house, if the tax issues, if there are income tax issues with the IRS or the comptroller, if those are things that are going to bog things down, then modify may not be the option because you have to do it within this time period. If you don't file the report within the 10 months, the registrar will undo the modified and make you a regular estate, and then they'll send you a letter saying it's been revoked and you need to give us an inventory and an administration account, well, usually within like 30 days. And so that's, you can't get an extension. You can file for an extension, I think like a month. They limit it because they want you to do it within this certain period of time. Otherwise, maybe they need to oversee it. Maybe they do need to be more involved. That's kind of the idea. And so that's one thing I've talked about with clients is if they realistically, let's say they're not organized, let's say they're not going to be able to get information, if they're not going to be timely with these things, then maybe modified isn't the way to go. This kind of goes through what the final report shows, debts, taxes, expenses, fees, other costs, and there's no gain or loss. And then these are just the forms for that. That kind of go, they actually have a packet on their website. I think Alice kind of showed you the website is great, very accessible. So these are where the forms are located. And with the election for modifying, the beneficiaries, they have to actually agree to it. So the PR elects, but the beneficiaries have to consent to it. And I think that's really it. So I was kind of close to time. Does anybody have any questions?
All right, thank you. You can put any questions in the question portion of the toolbox, but while we're waiting, I do have a question for you, Ricky.
Sure.
Okay, so with Medicaid recovery, so let's say the hardship exemption factors are not met. You mentioned the possibility of, I guess, Medicaid placing a non-interest bearing mortgage on the property.
Mm-hmm.
In your experience, like how likely is Medicaid to allow this as an alternative?
Well, I think they would though, right? Because they're going to get paid. So I think that option is not that bad for them because the person is going to pay the mortgage, and the person gets to live in the house. So I think that's kind of like a compromise that gets them paid, and the person gets to live in the house. So I mean, I think that depending on who you're negotiating with Medicaid, because of course you're going to be negotiating with an attorney there. I mean, I think that could be perfectly reasonable, as long as the person living there can afford to pay the mortgage.
Yeah, that might be a problem.
That's going to be the biggest problem. How financially feasible can they pay mortgage?
Yeah, I agree. That might be the biggest barrier.
Yeah, I mean I think that happens a lot even without Medicaid when you have a house with a mortgage on it and it's distributing out to the heir beneficiary. Can they afford to pay it? And that is often a problem, and that can hold up an estate distribution.
Let me see if there's any questions. Well, if there's no further questions, thank you, Ricky. Thank you so much. This is very
Absolutely, thank
informative,
you.
practical knowledge.
Absolutely.
So we're going to take another break just to give people another chance to get refreshed. So we'll resume the webinar at 11:25. All right, thank you. Okay, welcome back. So our next presenter is Cristin Lambros. So Cristin's practice focuses on estate planning and the administration of estates and trusts. She has a great deal of experience with property transfers within the context of estate planning and estate administrations. And we are fortunate to have her here this morning to share that knowledge with us. So with no further delay, I'm going to pass over controls to Cristin. So you're muted. Let me see if I can unmute you. All right, Cristin, so we have your webcam up so we can see you at the top and we can see your screen. For the attendees, there should be some controls at the top of the window that allows you to readjust the view. You can change the zoom percentage to make it fit to scale or actual size, whichever is most comfortable for you. We're good to go. But right now, Cristin, we can't hear you. Can you unmute yourself?
All right, so now I have control. All right.
Yeah. All right, so you're good.
Yeah, and I'm just trying to figure out how I can get this back on my screen. I did something to it. So Tim, I no longer see myself or my presentation. I just see that little dashboard. So what do I click on the dashboard to make me see what I was seeing before?
Your view before there should be a new window. There should be a window showing like your screen that popped up. Let me see if I can change your view. And you can see what the audience sees. There's a toolbar that says like audience view on the toolbar, and that'll show what.
Yeah. I see that. Let me make it bigger. Okay, that's not it. All right, let's see. So Tim, I think I'm just gonna sign back on. Is that okay?
Sure. Yeah, we're
Okay. All right,
pretty well on time, so we can.
okay.
All right, so we're just having a few technical issues. We're trying to get this Cristin's presentation on, so she'll log out and log back in. Hopefully, get that.
Yeah, I mean, I think. All right, I'll log out and log back in. Okay, sure. All right, leave webinar. Come. All right, I think I see what you see now, Tim. Can you hear me?
Yes, so I'm going to hand the reins back over now.
Yeah, okay, great.
Okay. Okay, so now we can see you and your screen. And right now we see the, I guess the email.
All right, so I only see me. Let me see.
So if you pull up the PowerPoint, I think that should be it, right? Because you're not really going to see anyone else. No one else's webcam is on.
All right, let me see. All right, just 1 second. I'm gonna log back in.
Okay.
All right, so now, all right, so now I think I can see what you see. But Tim, how do I make the slides go forward, or should I just tell you to do that?
Yeah, you can just tell me. You can say next slide, and I pull it.
All right, so let me move my little dashboard to the right, and let me make it full screen. All right, so sorry about the technological problems, but just a little background about me. I've been practicing in this area for 33 years. Early on, I spent 9 years at DLA Piper. I've had my own estates and trust boutique in Towson for 22 years. And I'm also an elected fellow of the American College of Trust and Estate Council. Now, in addition to my materials, most of which are actually examples of deeds, Tim, I sent you, I think, 3 other items this morning. Is that the kind of, how are people going to access those?
So I'm going to email those out to the individual attendees afterwards.
So, and let me just say this. I know you all have mentors, Maryland Volunteer Lawyer Services mentors, but you're also welcome to call me at any time. I have my info up on the screen right now. So the first thing I'm going to mention, and you might want to just take a few notes, is I sent to Tim something called resources. And you really can't practice in the areas that we're talking about during this seminar without really access to 3 key resources. So one of them is, it's called Maryland Real Estate Forms Practice. It was originally written by Russell Reno at Venable, and it's one of those 3-volume, hole punch pages where you get supplements periodically and you replace the pages. But that is sort of my go-to for deeds. They have a whole half of one of the books is just examples of many, many, many deeds. And that's sort of how I learned how to draft deeds over the years. The other book that's really essential to have access to is Jason Frank's. It's called Elder Law in Maryland. And that's a 1-volume loose leaf 3-ring binder that gets updated that tells you all the rules on medical assistance, Medicaid. And I have a little bit of that in my materials, and that's basically that's what I went to add a couple paragraphs to my materials. The third one that you really need is another loose leaf book. It's an MSA book. It's called Gibber on Estate Administration. And if you have Gibber, it tells you how to administer an estate from start to finish. And so you could really feel comfortable administering estate if you have Gibber. And then the other material I included is a couple of pages from the Maryland Lawyer's Manual. And so this is, and you can access the Lawyer's Manual by signing up on your MSBA, you know, under your login, and then you can go to Lawyer's Manual, and then you'll see in the table of contents, it's the very top, it's called White Pages, and it says MSBA Association, and then down on page 22, it has real estate information. And again, this is extremely helpful materials because, and one of the key things is, and I'm going to flip over there, well, it gives you recordation tax, state transfer tax, county transfer tax, real estate recording fees, real estate and personal property tax rates. But it also gives you miscellaneous recording information. Like, for example, in Baltimore City, a lien certificate is $55. In Baltimore County, it's $40. But I would say one of the most helpful portions of those materials is on page 26. And, you know, recording deeds can be a pain in the butt, and there are all these different steps, and you have to do it right. And I do include at the end my paralegals forms that we use, like enclosure letters to the court. But on page 26, they have something called Clerk's Office Assistance. The following persons at land records have been identified as persons who may be able to provide telephone assistance. And then they go down by the counties and give a person or person's names and their number. And I would say, if you're new at this, before you, as you're trying to record a deed, and a lot of times you can do it by mail, you will want to call the designated person in the clerk's office and make sure you're doing it the way they like it done. So I would say my next, so that's, oh, and another extra resource I have is, there are no, you know, the way you learn how to draft deeds is the same way you learn how to practice law. I mean, there are no generic forms. You basically start with another lawyer's document that is similar, and you know, make a copy and you edit it with all of your pertinent information. Now, there are a couple of references to language in the Maryland Code. And again, those PDFs Tim is going to send to you, but I've printed section 4202 of the real property article, which has the granting clauses. And when we go over a deed, I will go more into that. And then I also have included section 4204 of the real property article, but of course you can look these up on your own. And these are forms of acknowledgement. So, you know, anything filed in land records has to have a notarial acknowledgement at the bottom. And so this is just a sample form for that. But, you know, those are only two portions of a deed. So as I said, when I go to draft a deed, what I do is I start with a similar deed, and I have included for you a lot of what should be helpful examples. And so, you know, later on we have, well, so I'm going to go through the basic types of deeds, and I do have examples of all of them. But so you have fee simple deeds, and Tim, maybe we should, well, why don't we flip down to the personal representatives deeds for now. Okay. But before I sort of go over that specifically, the types of deeds you can have. So fee simple deeds, it's where you deed the property from the grantor to the grantee, and it's called a fee simple deed because the grantee owns it. Now in Maryland, we also have a peculiar animal, which is we have ground rents and ground rent deeds, and deeds of property subject to ground rents are not called, well, they're called deeds of assignments, and I have an example of that. So it's a little confusing, and Maryland is getting out of it, and I do have some of the Maryland forms at the back as well. But so basically what it is, it's like you own your house, except you have to pay someone who owns the ground rent, say $50 twice a year. And this amount is set forth in the deed. So they call it, you have a leasehold interest subject to the ground rent. So when you go to do a deed, you know, you may be, if it's subject to a ground rent, you would be doing a deed of assignment. Right now, you know, a lot of people are trying to consolidate. So like I had an estate recently where we were selling the decedent's home, and then we discovered there was a ground rent. And so what you have to do is you basically, the estate has to buy the ground rent from the ground rent holder. And I also have materials in my, I have forms in my materials on how to calculate the value and so forth, but then you buy it, and then you can do a ground rent deed to the personal representative, extinguishing the ground rent. So you are actually doing a fee simple deed, personal representative deed out to, you know, you might have a new buyer from the PR, or you might have it passing to, you know, the legatee. So let's see. So basically, so fee simple deeds, leasehold deeds, ground rent deeds. I also have life estate deeds with out powers and life estate deeds with full powers. And basically, as Alice mentioned before, you know, one way to avoid probate is if you do a deed from yourself to yourself retaining a life estate and showing, say, your child as a remainderman, then that passes automatically by operation of law at your death to the remainderman, and it never goes through probate. And those used to be popular in terms of people planning for medical assistance, but then they really cracked down on them. So I'll go through the rules about the Medicaid issues a little later on. And then when it comes to a fee simple deed, if you're deeding property to more than one person, again, as Alice said, there are basically three types of joint ownership in Maryland. You have tenants in common, where let's say it's held, like say I deed it to myself and my daughter as tenants in common. What that means is each of us has a half, and we can pass our half through our estate to whomever we want. And actually this comes up a lot. I have a lot of second marriages, and you know, and they're living in a house that one spouse bought, but the survivor doesn't want to be kicked out at death, and so maybe they'll deed it to themselves as tenants in common, because let's say the spouse who didn't own it put up an amount equal to 50% of the equity. And then, you know, we'll actually do a trust in the will where we deed the 1/2 interest owned by the decedent to a trust that the spouse is a co-trustee of, along with the decedent's child. And that way the the spouse gets to live there, but the decedent's property still goes down to his children, and then hers goes to her children. So that's tenants in common. We also have joint tenants with right of survivorship, which again, automatically by operation of law, the property is 100% owned by the survivor of the two of them on the first person's death. And you can have joint with right of survivorship with, basically anyone, including your spouse. But we also have the third type of joint ownership, which is tenants by the entireties, which, as Alice said, you can only have this form of ownership if you're married. And it also provides an extra protection in that if you have a joint tenants with right of survivorship deed, the creditors of one of the co-owners can get a lien and have the property sold. Whereas tenants by the entireties, the creditors of one of the spouses cannot get at the real property. So a lot of times when you have people in professions where they're worried about being sued, they want to make sure they own their house with their spouse as tenants by the entireties. So now I think what we're going to do is we're going to go through, starting with the personal representative's deed. And Tim, yeah, so we have that up. Now you might need to make it bigger. So I ended up including a lot, oh great, okay, a lot of deeds. So, and again, deeds aren't necessarily exactly the same because, for example, Alice's PR deed is slightly different from mine, and I can talk about the differences, but there are some basic, when you go to do a deed, the first thing you need to do is you need to get the prior deed. And Alice mentioned you would get it off of land records, which, you want to get access to. And you want to make sure it is the most recent deed in the chain of title. And then what you're going to do, as I said, is like, if you had an estate, you could take this form or Alice's form and then basically type in the information pertaining to your decedent and your legatees. And so the first paragraph, let me just see. Yeah, so basically the deeds, I mean, they all have these paragraphs in them. The first one is you say this deed made this day between the grantor and the grantee. In my case, in this deed, the grantor was the personal representative, but the grantor was also the legatee. So the grantor as personal representative was granting it to himself in his individual capacity. And then when you have a PR's deed, you sort of tell a little story. And I also wanted to mention in Alan Gibber's materials, Gibber on Estate Administration on page 1000, he has a sample PR's deed, which is actually, like this one, but it's just another one you can look at. So I basically tell this story. So the decedent died owning the property in this county, and then, the grantor was the appointed personal representative. In my case, you say when he was appointed, and this one was not intestate, so we did have a will. And then, as you know, title to assets in a person's name alone automatically vests in their personal representative at death. So the personal representative automatically owns the assets, obviously once they've been appointed. And so we do a recital here that says, pursuant to section 1301 of the Estates and Trusts article, the legal title passed to the personal rep. So the personal, you know, we were stating that the personal rep is the owner, even though there hasn't been a deed between the decedent's ownership and now. And then in my case, I referenced the item in the will that the grantee was entitled to receive the property. And in this case, as in many cases, it was a residuary bequest. So it's like I give the rest and residue of my estate to my son. And then we have the next clause. And this is where we have section 4202, but Tim, I'm actually still on page 1. Yeah, there you go. I mean, no, one more. Oh, yeah, perfect. Okay. So anyway, 4202 of the real property article, which you're going to get, these have sample granting clauses. And so my clause that starts with, oh, you're right, Tim, sorry, flip over, sorry. Yeah, so my clause that starts with, now therefore witnesseth. So that's the granting clause, where we are conveying the property from the grantor to the grantee. And you have to have this language in here. Now with personal representatives deeds, with gift deeds, with trust deeds, it's for no consideration. So you recite that. And so here we recite that the grantor, you know, actually has the power under the will, you know, to deed property, and also the power to deed property under Estates and Trust Section 7401 for zero consideration, conveys it to the grantee, which is the legatee, which is himself. And then you say his personal representatives, heirs, and assigns in fee simple. And then you describe the property. And one thing is, like when I do a deed, you know, you have to be very, very careful when you're doing it. So I've actually created a checklist that my paralegal and I use, and that I actually put the client name and the date, and I check the boxes and I include it in my client file just to have it there. So basically, as I said, I start with a form. And if, for example, my paralegal has done a draft, you know, I start by checking the format, you know, the line spacing, the indents, stuff like that, all the various parts. Then the next thing I check is the being clause. And the being clause is right below the lines. And in this case, it says, being the same lot of ground which were granted and conveyed. And this is where we list the prior deed that we pulled up from land records, and whoever was the grantor in that deed to the decedent. And in this case, it was his wife, and she predeceased him, and we never had to do anything there. Just like Alice said, with the bank account, you're not required to bring a death cert in and make it the surviving co-owner's name alone. You're allowed to keep it. So you don't actually do deeds when one person who owns it joint with right of survivorship or tenants by the entireties dies. You just recite it in this deed that he owned it because she predeceased him. And then we show the LIBOR folio. So the LIBOR folio you're going to find in the recorded deed. What happens is when you record a deed, the land records, sometimes it takes 3 months, sends back the original deed to the lawyer, and then you might send it to your client. But it will have recording stamps, usually on the top right-hand corner. And again, when you look in land records, every single document in there, you'll see the LIBOR folio, which is the book and the page. And that is the reference you have to make. And so, you know, this is obviously the LIBOR folio is something I check very carefully. And then you always do have the next paragraph where you cite together with the buildings located on it. And Tim, I think we can flip to the 3rd page of this deed now. So then what we have next is the habendum clause. And this is basically how the owner owns it. And in this case, again, it's just sole ownership, you know, and so you sort of repeat the language you had above in your granting clause. So you say to have and to hold to the grantee, and then you say his personal representatives, heirs, and assigns in fee simple forever. So this is where you put your forever in. And so basically what you're saying is you're not only deeding it to, in this case, the legatee, also his personal representatives could own it, you know, and so you always have this same language. And you know, like if you were deeding it to a trust, you would just say something like its successors and assigns. So it is geared towards the you know, language of the person who you are granting it to. And I have deeds later on that show the joint tenant language. So, and then you have to have the witness, and then you have the notary, or they call it the acknowledgement. And again, in the materials Tim is sending you, section 4204 of the real property article, that gives sample acknowledgement, but it's a pretty straightforward thing. It's, you know, basically what the notary has to, the deed has to be signed in front of the notary, and they have to sign it, date it, and put their notary seal. And you know, I happen to be a notary. It's really quite helpful. It's pretty easy to do. You just contact the person who represents you in the state legislature, and you can file an application. So, but when you are a notary, you're supposed to keep a notary book. So, and you put in the book how you knew the person, whether, you know, and in my case, most of my clients, I know them by personal knowledge. But in some cases, you'll see notarial provisions which say, known to me or sufficiently proved to me to be the person who signed the above referenced instrument. And then for deeds in Maryland, you have the attorney certification. So basically deeds have to be prepared either by an attorney under the attorney's supervision, or also individual parties to the deed are allowed to prepare their own deeds. But I actually have never seen that. And then you see at the bottom, it says return recorded deed to my address. So Tim, can you go down and make it a little smaller so you can see the whole bottom part? Yeah, okay. And then as I said, they mail it back to you. Now, I guess it's probably helpful for me at this point to flip to the back of my materials. And so Tim, it might be best if you just go to the end. I don't have page numbers, but, oh, I can. Okay, so what we're going to now is the memo to the client. When we say we want these fees, so it's a couple up. One more, keep going, that one. Okay, so, and you can probably make it a little bigger somehow. Okay, so anyway, so when you're doing a deed, you do have various recording fees. You know, we like to get our people to bring in the appropriate checks made out to the appropriate people. So there is a process that you'll see over the next couple of slides where in order to record a deed, it's a multi-step process. And the first process is you're going to get a lien certificate. And we'll go through it in a minute. I have the application for lien certificate in the materials. And basically what you have to prove to the land records before you can deed property from one owner to another is that all the real property taxes are paid up to date, and things like the water bill as well. So, you know, one thing you want to make sure before you even try to get a lien certificate is ask the client to confirm that all the you know, real property and water, et cetera, bills are paid up. So anyway, so there are various costs for that. You can see at the bottom of this memo, Baltimore County, it's 55. It's 55 for Baltimore City. The second step of the process after you get back the lien certificate, which is only good for, I think, about 45 days. So once you get it back, you want to then send it with the deed for recording. And then you'll see we also have listed, in this case, it's $60 to record the deed with Baltimore County as well as Baltimore City. But the real property pages I mentioned to you before in the lawyer's manual will show you all the different lien certificate amounts and recording cost amounts pertaining to whichever county you were recording in. And as I said, it's also a good idea just to call the representative who is there to help you, which is page 26 of those materials, and just make sure you're sending the right amount and to the right person. So Tim, the next page is the application for lien certificate. And that one is for Baltimore County. Baltimore City is slightly different. And you'll see at the top, it says each application must be accompanied by a fee of $55. And then you can flip to the next page. This is actually our enclosure letter that we send to the court with our check and our lien certificate. So it just says enclosed is a lien certificate, and then please send it to me. Now, the next one I want to go to is, go 2 slides down, please. So go to the next one's, yeah, that's great. Okay. So this is the letter once you get your lien certificate back and you're mailing the deed to, you know, court, to land records to record. You actually send everything, and you can see I have the deed, an original and a copy. Then I have 4 copies of the intake sheet, which I'll go over in a minute. You know, and my check and an envelope so I get the deed back. And there again, we're requesting, so we're sending it to the Office of Budget and Finance, and then they'll send it on to land records, because Budget and Finance has to certify to land records that, you know, all the real property taxes are paid and that land records can in fact record the deed. So on the page before is the Maryland Land Instrument Intake Sheet, and Alice also showed you an example of this. So it is online, and you know, in each deed I have, I do show the tax exemptions. So like she said, you know, with these kinds of no consideration deeds, they're exempt from transfer taxes, and recordation taxes. And Alice did give you some good examples. So up on box 3, Tim, I don't know if you can make it any bigger, but it's like the 3rd line down. Yeah. So that's where 1, 2, 3. Yeah. So it just gives you the blanks there. And Alice actually filled in the numbers from the Maryland, the sections from the Maryland Code, which means that you do not have to pay recordation, state transfer, or county transfer taxes. And as I said, I actually have this in the last paragraph of all of my gift deeds. So I think what I'm going to do next, Tim, is let's just flip quickly through some of the other deeds, and I'm going to just point out a few things. So let's go back to the deed after the personal representative's deed, which is called deed of gift. Okay. And let me actually just pull my materials up over here so I can be on the same page with you. All right. Because my screen is tiny. Okay, so, all right, so deed of gift. So this is from parent to children as tenants in common. Okay, so I mean, you know, the thing is, as Alice said, you know, a lot of times the house may be the only thing you have in the estate, because other assets like bank accounts or, you know, IRAs or insurance, like for example, on the bank account, you can just make it payable on death to your child, and then you never have probate. But you know, deeds, you have to go to a lawyer, and you know, a lot of people can't afford it. And so this happens to be the only asset that wasn't easily transferable during life that we're stuck with in an estate. And again, sometimes, I mean, I've had estates where it goes like 3 generations back. Like, so the grandmother owned it, and then the mother lived in it, and then the granddaughter lives in it, and now the granddaughter died, and I, in order to deed it out to the, let's say, intestate heirs of the granddaughter, you have to open the back estates. And so it can be, you know, a real pain in the butt, but that's what you have to do. And so, you know, you can, but obviously if the person qualifies, Tim, I don't know if we actually do any gift deeds, but, you know, a life estate, deeding something to yourself and your child with a life estate remainder is, you know, a gift deed. It's just, in these gift deeds that I have, the grantor is no longer the owner. So like in this one, it's from a grantor to his kids, and then you'll see in the first paragraph, if you can make the witness if that paragraph bigger, so that's where you'll see the tenants in common. Okay, so yeah, that one. Yeah, so it basically says grandson conveys into the grantees as tenants in common.
Yeah, I can't zoom in any further, unfortunately.
That's good. No, that's good. Yeah. And then later on the next page, you have your habendum clause, which says to have and to hold unto the grantees as tenants in common, their personal representatives, heirs, and assigns in fee simple forever. And then after that is where I recite the sections of the Maryland Code, why this one is not subject to recordation or transfer tax. Now, one thing I did want to point out on the personal representative's deed, but Tim, you don't have to flip back there. It's just, as I said, you know, lawyers basically draft deeds based on ones they or someone in their firm has done before. And so all the deeds won't look alike. And but you do want to know why all the paragraphs are in there. And one thing is, like in Alice's deed, and I did, Tim, one of the additional items I sent out is, it's called Maryland's withholding requirements for sales or transfers of real property by non-residents. And so Alice's deed had a little certification before the lawyer's certification about the non-resident requirement, but the materials I sent you, there's a whole question and answer part, and like on page 20, 21, and 22, it makes clear that you actually do not need that certification, and in no consideration personal representative's deed. But there was some confusion. That was changed briefly in 2003, and then they changed the law a little more, Tax General 10912, to make it clear that we actually don't have to have that for a no consideration deed. All right, so then the next deed, Tim, if you can flip to that one. All right, so this is a deed, basically a deed from my client to her and her husband. So bottom line is she owned the property, she got married, and she wanted to deed it to herself and her husband as tenants by the entireties. And again, you know, the key clauses are the now therefore clause, which is the granting clause. Then of course we have the being clause, the together with the buildings, and then we have our habendum clause, to have and to hold as tenants by the entireties, their personal representatives, heirs and assigns, and fee simple forever. And then I do reference, you know, the code sections whereby it's not subject to recordation or transfer tax. Now, this property happens to be in Baltimore City, and Baltimore City has this extra requirement that we address, which is right before the witness line, which says the grantor by her execution hereof hereby certifies that the within property in Baltimore City has not been occupied by a tenant for the past 6 months. And then the grantee, which certifies that they'll continue to be occupied by her and her husband. So she's the grantor and the grantee. But bottom line, there is a right of a tenant, right of first refusal to a tenant in a house in Baltimore City. So you will have this extra paragraph on those kind of deeds. And now I just wanted to sort of go back and tell you what else I do when I'm checking a deed. So I check the format. As I said, I check the being clause. Now, the description, the property description, and I don't really have, I mean, we basically blanked out the property description, but it's like, let me see, one of them. All right, so Tim, if you can flip to deed of gift, which is deed from parents to their daughter as joint tenants with right of survivorship. And I could tell you what slide it's on if I arrow down. Okay, so it's the next one after this Baltimore City one. Okay, so that one I actually do have a little bit of the description there. So see where it says being known and designated as lots number such and such and such and such, section G on the plat of Yorkshire, which plat is recorded among the land records of Baltimore County and plat book number folio. And then the improvements being known as, that's just the address of the property. So the thing is what I used to do is, you know, we would read aloud word for word this property description, because it's essential to get it right, and all the way down to the punctuation and the capitalization of letters and the spacing. Because this is, you know, there's a chain of title where we're passing this property down, and, you know, we base the description on the deed before it, and the deed after it has to be precisely the same. And so again, we would read it out loud. So I would read this, something like, all caps being known and designated as capital L lots, capital NOS period, you know, and so forth. And so one, like I might be reading it and my paralegal might be checking that it's precisely that, because you really can't rely on having the old deed and the new deed together and running your eye back and forth across both. There are, you know, basically some mistakes happen that way. Now, another thing we've been doing lately, which is really good, is, you know, what my paralegal will do is she'll go to the old deed and she'll cut the property description out. and she'll insert it on a Schedule A attached to the deed. And so basically what we would say in this, instead of this being paragraph where we say being known and designated as, we would just say, let me see if I have any examples, but we basically refer to Schedule A. I guess I don't have that many here. Yeah, but anyway, so you're just saying for property description, see attached Schedule A. And as I said, if you copy it electronically and cut and paste it as a text box on your Schedule A, then you're good, because you don't have to obviously read it word for word. But you do want to be careful when you pick up the description. You know, a lot of times you see after my description, I have my being clause. So sometimes when preparing deeds, people shrink that being clause to the single space, like and in the same size as the description above. And so when you go to cut and paste, you really only need to start with being and end with the improvements thereon being known as. You don't need to attach the prior being clauses that sometimes people inadvertently do. And then, you know, I actually, you know, when I'm back to my checklist, I actually ask my paralegal which deed she started with, and I do check the new deed she's prepared against the form of the old one, just to make sure, you know, because you want everything to be really precise. And, you know, you're fiddling with the language each time, so changing it slightly, and you just want to make sure the language in the new deed, you know, still reads properly. And then what I always do is I check it against the prior deed. So like the deed we printed from land records, because sometimes you'll have provisions in there, and I probably have them on my, in some of my deeds. But it's like, it'll be subject to an easement of right of, like, you know, the county to access the sewer line or something. So so sometimes you'll see things that have a saving and accepting or a subject to, and you want to make sure you include those, you know, as paragraphs in your new deed. And then I guess another thing to be aware of, and I do have, Tim, we have a deed that's a condominium deed, and let me see if this one is it. This might actually be it. Let's see. Let's see. So condominium deeds have have a couple extra paragraphs. Let me just flip over to yeah, I mean, it'll say being the same condominium, blah, blah, blah. And then it'll usually have a paragraph that says subject to the limitations of the condominium rules recorded in this plat of this deed book. So as I said, one of my deeds has that in the document, and it would be sort of right after my being clause. And so it would be a subject to clause. So then what I do is I, again, read the deed word for word and make sure there are no mistakes, you know, and then I get my client to sign it. So I just want to go through some of the others. So the deed that Tim has up now, Tim, I don't know if you can make the witness clause on the first page any bigger, but I just wanted to point out, so this one, to avoid probate, the basically the property was owned as tenants by the entireties by parents, and they deeded it to themselves and their daughter joint with right of survivorship. So what that means, you know, one parent will die, the second parent will die, and the daughter will automatically own it. Okay, and then let me see, the next deed I call, let me go down there on mine, over here, okay. All right, so now I have a deed, which is life estate, no powers. And this one is from parents, and they're reserving a life estate with no powers, and they're giving the remainder to their daughters as tenants in common. So you'll see in the witnesses that granting clause, it says the grantors, you know, for no other consideration, blah, 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 but subject to the reservation set forth below of a bare life estate with no powers, grant and convey to the grantees as tenants in common. So basically they're granting it to the daughters, but they are reserving, in this case, a bare life estate. And then you'll see that same language on the next page in the habendum clause, where it says to the grantees as tenants in common, but then it says reserving that bare life estate with no powers. So, you know, what a bare life estate is basically you have given up your right, like you can't change it. The next deed we're going to do is a life estate with powers, where you are allowed to sell it or mortgage it or transfer it. And so the remainderment's rights really only are set after the death of the first tenant, you know, basically the parent in my example. So, and, you know, so the bottom line is, and I've had this happen before, I have a client who, she deeded, before she got to me, she deeded a piece of property from herself to herself and her daughter as joint tenants with right of survivorship. And then she decided she wanted to sell it, and because it wasn't her main house. And she first asked her daughter to deed back the remainder interest, and the daughter refused. And then of course she asked the daughter at settlement, okay, I want to check for the whole thing, and the daughter refused. And so bottom line is, you know, they sold it to a third party. At settlement, both the mom and the daughter were there, and they basically actuarially calculate the value based on tables of the life estate and the remainder. So you take the value that you're getting for the dollar value you're getting for the property, and you multiply it by these percentages to come up with, you know, the value of the life estate and the value of the remainder. So that's basically how that works. Now, and it used to be the case for Medicaid purposes, there was an advantage to this life estate with no powers. You know, because why would you do it otherwise? So the life estate with powers is the next deed, and there you'll see we say in the let's see, witnesses, okay, the grantors subject to the life estate and powers hereinafter reserved. So that's in the witnesses, the granting clause. And then you'll see on the second page, oh, actually this one is my condominium one. So you'll actually see after, and it's after the together with the improvements, where I say this deed is subject to blah, 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 covenants, declaration and bylaws of that condominium. But going further down, we have our reserving the full powers. So you'll see in the have and to hold paragraph, it says, but reserving unto the grantors as tenants by the entireties and the survivor of them and the survivor's personal reps, heirs, and assigns a life estate in the property for their life without liability for waste, and also reserving unto the grantors the full power and authority during their lives to sell, convey, and dispose of their property except by will, and to retain all of the proceeds, and thereby divest the remainder granted in this deed, and that they can the right to mortgage the entire estate, including the remainder. So that's the life estate with full powers. And the next slide I have, Tim, is the sort of discussion on Medicaid. Yeah. So I go through here, you know, so we've seen like 3 types of deeds where we have a parent deeded to themselves and a child. So I had the one where the parents deeded it to themselves and their daughter as joint tenants with right of survivorship. And let's say my example was it was the surviving parent and she added the daughter to it. And then I have, you know, the example, again, let's take a single person where the parent deeds it to the child, life estate full powers, life estate no powers. So Medicaid treats these differently. And again, you'll want to access Jason Frank's elder law book. But basically, you'll see that the life estate with full powers, and I give a little summary. And then basically the rule is because the life tenant can sell the property, Medicaid considers the full equity value as available. And so bottom line is, you know, when you're applying for Medicaid, you can't have very many assets. And so even though this property automatically on your death is going to be owned by your daughter, they still consider it an asset, which will prevent you from qualifying for Medicaid. And then the next one, the life estate without powers. So this one, it's basically the creation of the life estate is treated as a transfer subject to a penalty. And so, and they use the full value. So let's say the property was worth, let's say $91,250. So what you have to do is when you want to apply for Medicaid, medical assistance, they look back 5 years and they penalize you so that you won't qualify for Medicaid. They have a divisor, which is basically roughly the amount of what it costs per month to be in a nursing home in Maryland. And so you are, you know, you're penalized by 1 month for each. So basically in this case, last time I looked in Jason's book, the divisor was 9125. So it was $9,125 a month. So I basically take my 91,250, divide it by 9,125, and I'm disqualified for 10 months. So that means I have to have enough other assets to pay for my own nursing home for those 10 months after I give it away. And so, you know, medical assistance is a whole nother topic for a whole nother course. And again, they have changed the rules during the time I've been practicing. It used to be a 3-year look back. You used to be able to do certain kinds of trusts. So, and then my last type, which is the joint tenants with right of survivorship. So this is how they treat it. Basically, when you add the daughter's name, what this means is, as with my example before, where I had a life estate with, well, actually, joint tenants with right of survivorship, where I had that deeded from the parents to the daughter. And again, let's say it was the surviving parent to the daughter. The property could not be sold except for both of the joint tenants. In this case, mother and daughter, being, you know, on the listing contract for sale and at settlement, receiving the money. So the Medicaid deems this to be a transfer subject to penalty, just like the life estate without powers. Now, I'm going to quickly go through a couple of ground rent deeds, just because you will come across them and it's important to know sort of what they are. So, as I said before, this deed next, this deed of assignment, it's basically, in this case, the dad and his daughter and the daughter's husband bought the house, and it was subject to a ground rent. So, you know, they own the house, but they have to pay this ground rent twice a year. And that is actually over on the second page, and it's in the habendum clause, the to have and to hold clause. And you'll see that in this case, you know, this is a second deed in a series of deeds. The dad is actually deeding his tenants in common interest to the kids as tenants by the entireties. But again, the property is subject to a ground rent. So we say there, to have and to hold to the grantees. It says, for all the rest and residue of the term of years yet to come and unexpired therein, with the benefit of renewal forever, subject to the payment of an annual ground rent in the amount of $78 payable half yearly on the 26th of April and October in each and every year. So, and who they pay it to, there will also be a ground rent deed, which I have one coming up. So you can, as the person who receives this, this ground rent twice a year, you can actually sell it or give it away and do a deed of ground rent, in which case these owners with the leasehold interest have to pay the new person under the new ground rent deed. And you will find this is a huge pain in the butt. And, you know, you'll even find, like, I have these people. So at one point, I don't know, maybe in the 1940s, this was very popular, and you would have these, you know, people who would buy and sell ground rents and hold them. And I even had one estate where we had 200 ground rents. And so, you know, it's just an investment, but they're such a pain to sell and get rid of that sometimes, again, this may be the only asset you have in the estate, and it's not worth very much. So I want to flip to the next slide, which basically this is something Marilyn put up on the web, which is extremely helpful. And I'm going to, Tim, flip to the second page where it says calculation of redemption amount. So, so basically, so let's say, and I'm going to take the interpretation, I'd have to think about it for a minute, but when it said payment of an annual ground rent of $78 payable half yearly, what that basically means is I have to take my $78 and divide it by 2, and actually they have to pay $39 twice a year. So over on the ground rent calculation page, so we're going to add the ground rent annual payment, which is $78. Okay, and then we're going to divide it by the applicable rate. So on the prior page, the rate we divide it by to come up with the value is based on the prior deed. So I'm going to look at the deed I gave you an example of and see being. So in my being clause, let's see. Well, I guess actually I probably need the ground rent deed. Divide the amount by the applicable rate, and on the first page, the ground rent lease was created on. Yeah, so I need the ground rent deed to find out which divisor I have here. But let's say it was the first, number A, July 2nd, 1982 or later. So then we have a 12% redemption rate. So then we put the 0.12 under our 78, and then we come up with, so we take 78 divided by 0.12. All right, so that means this ground rent is worth $650. Okay, so what most of my personal representatives do, like I had another one recently where, we were selling real property in the estate, but it was subject to a ground rent. And I always tell my PRs to contact the ground rent holder, in other words, the person to whom you pay your $39 twice a year, and offer them maybe $500 for the ground rent. So in other words, you don't have to start at this actual value because, like any other real property sale, it's willing buyer, willing seller, arm's length transaction. So you can start by offering the ground rent holder less than the value, but they may hold you to this $650. All right, so then, Tim, the next slide is actually a deed in redemption of ground rent, which again, Marilyn put up on the internet. And so basically, once you agree on that purchase price, then this is actually designed so that, I have one typed into my forms as a form, but this one, it looks like the people could do by themselves, maybe even without your help. But so it's pretty straightforward. I want to point out on the next page where it says to have and to hold, it goes on to say, to the end and intent that annual ground rent and the reversion thereto may be forever merged and distinguished, and the grantees herein being the owner of the leasehold interest estate in the property described above. So again, I had one of these recently. We had a contract to sell the house. They discovered this ground rent. In this case, it was actually owned by the father who predeceased the mother, and we were doing the mother's estate, so we had to open his estate too. But at any rate, we deeded it, from the purchaser to the estate, and then the estate could sell it to the third party buyer, and it could be a fee simple ownership without, not being a leasehold subject to a ground rent. And that pretty much covers my slides. As I said before, if you have any questions, you're perfectly welcome to call me at any time. I'm happy to help out. And Tim, I don't know if anyone has come up with any questions while I've been talking. If so, you can read them to me, I guess.
Yeah, we do have a few questions actually. So I can start from the top. Let me pull up the question pop out here. Okay, so I guess the first question was, do you have any reservations about notarizing documents that you also prepare?
No. Lawyers do it all the time. I mean, when I was at Piper, we did it all the time.
The next question is, and I guess this is for also possibly all the presenters, but are the presenters aware of any laws in other states that make resolution of tangled title situations easier?
Well, I'm not sure I understand the question, but basically, whichever jurisdiction the property is located in, you're stuck with doing it that way. So like we practice in Maryland and, you know, our clients or decedents own Maryland property. And so this is what you have to do. So Tim, if you can address that anymore, I'm not sure I totally get it.
Well, I'm not personally aware of any other. I know about. Well, I'm aware of like the Tangled Title Fund in Pennsylvania that allows for people dealing with this type of situation to have some type of recourse. But that is the extent of my, I guess, out-of-state knowledge. Do any of the other presenters have
Well,
any other?
actually, Tim, there is one thing that you do come across. All right, so some other jurisdictions have what are called quitclaim deeds. But if you look at the materials that Russell Reno's book, which is the Maryland Real Property Forms, he advises that in Maryland, we do not do quitclaim deeds, which are supposed to be simple deeds that are just, you know, 1 or 2 pages and do purport to be an easy way to transfer title without a whole lot of, you know, possibly the steps that we're doing here, but we do not do those in Maryland.
Okay, so this next question is it's about the mechanics of recording the deed. So where do we file the deed of gift once it has been completed? Also, does it need to be notarized?
A deed needs to be notarized. There are notary acknowledgement provisions on all of my samples. You file it in the county in which the property is located.
So it's actually, this next question actually touches on quitclaim deeds. So do you prefer fee simple deeds versus quitclaim deeds? If so, why? Is it because of the title insurance issues?
Yeah, I mean, as I said, we do not do that in Maryland, and it's not advised by real property lawyers. I can, if the person wants to email me, I can send them the portion of Reno's book that talks about quitclaim deeds. And I could actually, Tim, I'll send it to you and you can include it in the materials you're sending out, okay?
Okay, that works. Okay, so when is a life estate deed a good idea versus a tenants in common?
Okay, read that again, please.
So when is a life estate deed? Sorry, so when is a life estate a good idea versus tenants in common?
Okay, so the thing is, like the problem with tenants in common is the creditors of the co-owner could get at your property. So if you have a life estate deed, you protect yourself from the next owner's current creditors.
Okay, so the final question is, do you still have to escrow 3 years of ground rent as part of the redemption process?
The last couple ones I did, everything was up to date, and we just offered that $650 and it was accepted and we did the ground rent deed. But again, those materials that I included in my outline are from, you know, the Maryland put them up on the web, and there is one page that I didn't include that's also an instruction page. So, you know, I don't see anything that says that. But again, you might want to, Tim, I can include a link to that website that you can send out to people, okay?
Okay, I can do that.
Tim, just to jump back to the prior question about tenants in common and life estate deed, just to clarify, tenants in common deed does not avoid probate, whereas a life estate deed, a joint tenancy deed, a tenants by the entireties deed, those are tools of estate planning that can be used to avoid probate.
All right, thank you.
And again, adding on to that, Tim, I mean, you know, clients do ask, should I let my real property just pass as part of my estate under my will, or should I do a life estate deed? And generally speaking, if you have a client who is widowed and has 3 kids, I would advise not to do a life estate deed where you deed it, as one of my examples did, from parent to 3 kids as tenants in common. It's much better to have it pass in the estate, because then the personal representative has leverage, and one child can buy out the other 2 with portions of their inheritance, or by getting a bank loan. And if they can't come up with that to pay off their siblings, then the PR might have to sell the property. And so I would say one of my biggest problems for estate planning among generations of families is, and this is slightly different from the MBLS clients, but there might be a vacation home. And like, I have one where the parents owned it. It's up on an island in Maine, and there's 6 kids, and they've used it for generations, and they want the 6 kids to be able to use it. And you would never in a million years want to deed it out as tenants in common, because no one would ever agree on anything. Someone would probably end up paying the real property taxes, and the co-owners probably wouldn't, and the person who pays them couldn't force payment by the others. So again, like if I have an estate, I generally, probate is really not that hard. So, unless it's like a mom with a sole child, you could do it, but I don't normally do it to avoid probate.
All right, well, thank you. We actually have a few minutes, so if there's any questions, I guess, for the panel at large, we can take those in. A few more seconds to type them in. They're typing. All right. Okay. Well, I just want to extend, I guess, my deepest gratitude to our presenters, to Alice, to Ricky, and to Cristin for your time and your knowledge today. I really appreciate it, and I'm sure the volunteers do as well. Thank you.
Okay, thank you.
Thank you, Tim.
Thank you.
I'm just going to close up with a few last housekeeping things. Let me pull this up. So, if you're looking for pro bono cases, you can always check out NBLS's pro bono portal. That can be accessed through our website, nblslaw.org. And you can just click on that red circle pro bono portal at the top there. It looks like this. Oh, sorry. So you can filter out cases by types, depending on what you're looking for. If you're looking for like an estate administration case, it would be that dark reddish color. And if you want to find out more information about it, you can click on Learn More and get in touch with one of our paralegals who could explain further the details of the case. We have further trainings coming up. These are live webinars. If you're interested in any of these topics, I strongly advise you going to the website to register at nblslaw.org/events. We also have free recorded trainings. So like I mentioned at the top of this training will be recorded, as are our past trainings. And you can access those through the NBLS Law website as well. If you're not yet a volunteer, you can sign up today at this website. If you're on the fence about volunteering, I strongly advise it, because if you're nervous about not being fully, I guess, well versed in the area of law, we offer many areas of support. In addition to the trainings, we also offer mentors who can guide you through the trickier areas that you're not familiar with. We also have malpractice insurance for our volunteers. And we have the use of our offices to meet clients in this non-crisis circumstances. And also, another resource we have for volunteers and clients alike that Alice and Ricky alluded to is our Catholic Charity Fund. So we partner with Catholic charities who can cover the estate costs for clients over the next year through June 30th. So these fees include probate fees, bonding, publication fees, lien certificates, recordation fees, and copies of death certificates. So we talked previously about how there's a financial barrier for many of these clients, and this fund can help alleviate that. So do not hesitate to reach out to us about that if you're interested in volunteering in an estate administration or deed transfer case. That concludes the webinar for today. Thank you all for attending, and take care.